is because of the special lockdown. All our ADAs are forbidden from coming in the building. I forgot about that.
Nobody forbade us for anything.
No, me neither. Mute that. Got it. All right. So good morning, everyone. We are waiting on inmates. They are in the building, but they are being processed down below. So if we have anyone on bond, we could handle those cases first. But once the inmates are brought up, we're going to try to do Mr. Vaughn's pleas. So Ms. Willingham's blood pressure can go down. And we'll do Mr. Mundy's plea, and then anything, Mr. Abate, you've got, we can try to cover, because I know you and I think you and Ms. Feely need to be with Judge Dempsey at 10, although he knows to hold for your report.
Judge, my client's on bond as well. This is for Lord Bastian.
Hey, Mr. Bastian, how you doing?
I'm good.
Who's your client? Is that Miss Smith?
Yes, Miss Smith and Miss Saunders.
Okay. Are either of them on the call, or are they coming into court?
They're both on the call.
Okay. Well, why don't we get started with that, and then when the deputy appears, we can pivot to Mr. Vaughn. I don't see Mr. Vaughn on the calendar. That doesn't mean we won't handle him. It was a carryover from last week.
There was a separate calendar, so now.
Okay.
Judge, I'll send it to you.
Okay, great. Thank you. Who is handling Ms. Smith's case for the state?
That would be me, Your Honor.
All right, let's get everyone on the screen. So there's Mr. Peoples and Mr. Bastian, and then Ms. Smith, are you on? And if so, can you let me know where you are? Bet you're this one. Ms. Smith, we need you to turn your video on.
I see her.
I see a Lashandra.
Yeah.
We can pivot to Miss.
Good morning, Judge.
Uh-oh.
Not sure who that is. Oh. All right, so that's, there she is. All right, we've got Ms. Smith on the screen. Ms. Rivers, good morning. Are you ready to take things down?
Good morning, and yes, I am.
Great, let's do that. This is position 7 on our calendar, State versus Lashandra Smith, 22 SC 181348. Ms. Smith is charged with aggravated assault and false statements, and today is her final plea date. It was rescheduled a few times because one, we were trying to get Ms. Smith a lawyer, and then we did. That's Mr. Bastian, and he understandably wanted some time to get up to speed on her case. Mr. Bastian, do you have all the discovery in this case?
I do, Your Honor. I think we got an agreement, Your Honor. We might be able to do a plea right now, if Your Honor would.
Okay. Mr. Peoples, is that your understanding of what's happening?
It is, Your Honor. I just like 2 seconds. I just sent Mr. Bastian a message just to clarify and make sure that we were on the same page. If he'll just check his chat real quick.
Okay.
Okay, I'm checking my chat right now real quick.
On the Zoom.
Okay. Okay, I see an agreement. So that's fine. I guess we'll change it to a misdemeanor disorderly conduct or something, right?
Let me make sure Ms. Smith is in a good, safe spot and is not driving. Ms. Smith, I think you're in a car, which is ironic given what the charge is. You're not driving right now, are you?
in my apartment building now, Judge. Give me 1 second.
Okay, you let me know when you've pulled over in our stationery and we will take care of your case.
All right, I'm stationary.
Okay, are you able to hear what we're saying?
Yes, sir, I can hear clear as day.
Okay, good. Well, we're going to go forward then. In a moment, Mr. Peoples is going to put you under oath. When you're under oath, make sure you answer all his questions truthfully. If at any point you need to speak with Mr. Bastian in private, I will move the two of you into a breakout room, okay?
Okay.
All right. Ms. Smith, before Mr. Peoples gets started, you have a right to be here in court, but you don't have to be. It looks like you're in a vehicle instead. Are you waiving your right to be here in court for your plea?
Yes.
Okay. You also have a right to have Mr. Bastian right next to you, but he is in his office and you are in your vehicle. And I've told you I can set it up so the two of you can speak privately. Are you comfortable proceeding with Mr. Bastian in his office and you in your mobile office?
Yes.
Okay, well, we're going to do that. Mr. Peoples, when you're ready, please.
Thank you, Your Honor. Just one moment, Your Honor. Of course, the day we're here, technical difficulty. I do apologize.
Hold on 1 second. They're not even in the building? Okay, well, we're going to take a plea right now virtually. Can you get with Ms. Nelson on that? Okay, yes. Ms. Nelson, I need you to plug in with Deputy Gordon. We have a couple folks who don't seem to have been brought over and they're going to need to do that at some point today.
Okay.
Ms. Feely, do you expect that you'll be back this afternoon? I don't know how long is it Simpson or Mitchell? Simpson. I got the last name wrong. Mr. Simpson, you don't think that'll be an all-day situation?
And I have stuff on the Monday account.
Okay, so if we get Mundy and Vaughn brought over this afternoon, that would work for you. Ms. Willingham, I'm sure you're putting your head in your hands on this, but if we get Mr. Vaughn over here this afternoon, will you be able to rejoin us?
Yes, Judge, I will. And with that, I am covering positions 5 and 6 on the plea and arraignment, but can I log into Judge McAfee and then I'll come back?
Sure, we're going to take this plea now and we have other business we can cover. So just rejoin us when you can.
Okay, thank you.
All right.
And Judge, I do apologize. I'm having some technical difficulties. It looks like Odyssey is not working for me. I'm just trying to pull up the.
So that would be a good reason to be in the building.
Understood, Judge. That's above my pay grade. I do apologize. It was just working yesterday. One moment.
Tell me what you need from Odyssey.
I was pulling up the police report for the factual basis. It looks like Odyssey is not allowing me to open anything that has a PDF. It'll allow me to open Word attachments, but it won't allow me to.
Okay, I'm gonna have you pause for 1 second. Do you know, is Miss Culpepper here? Did that person get brought over? Or he or she? I think it's a she.
I was going down to check the female side.
Okay, because we've got someone on the call asking if Miss Culpepper's here. So if you could let us know when you come back, that'd be great. So Mr. Peoples, let me see what I can do to assist this one time.
Thank you, Judge.
Where would I find the police report?
In hours, Your Honor, it would, once you open the actual file itself, we're able to see the warrants and report anything that we've updated. I'm not sure why Odyssey, for me is not.
I'll send it to you, Dion. What's the case number? I'll go into attorney manager.
Thank you. It's 22 SC 181-348.
SC 181
348.
348. All right, you should have it in 2 seconds.
Thank you
Great,
so
let's
much.
get going.
I do apologize, Judge.
All right, Ms. Smith, we need you to come back on the screen, please. There you are. Okay, let's take care of this. You ready?
Yes, sir, I'm ready.
Okay.
Thank you. Ms. Smith, are you able to hear me?
Yes, I can hear you.
Thank you. Can you raise your right hand to the best of your ability? Thank
There
you.
we go. We can see it.
Do you solemnly swear that the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can lower your hand. Will you state your true, correct, and legal name for the record?
Chandra Century Smith.
Thank you. Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you?
I'm 29.
And what is the highest level of education that you've completed?
Technical college.
Did you finish high school?
Yes, I did finish high school.
Okay. Are you able to read, write, and fully understand the English language?
Yes.
Okay. Do you understand that you're charged with the following offense? 1 count of aggravated assault with a sentence range of 1 to 20 years and false statements with a sentence range of up to 12 months. Do you understand?
Yes, I understand.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a trial by jury?
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with his services?
Yes.
Counsel, do you waive formal reading of the indictment?
I do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes.
Ms. Smith, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court would be a sentence of, Your Honor, we would be asking that count 2 be null pros and count 1 be reduced to criminal trespass and the sentence of 12 months of probation and completion of an anger management course. Attorney Bastian, is that the recommendation understood by you and your client?
Yes. Yes. You
So
understand?
go ahead, Mr. Bastian.
No, I just wanted to reiterate to Ms. Smith that the other charges are not there. It's criminal trespass. Do you
Right.
understand?
Right. I was wondering because I'm criminal trespass and I'm confused. He was at my house.
So, Ms. Smith, hold on. So 2 things. 1, the state's dismissing the false statements. And then 2, this criminal trespass charge it can mean that you are on someone else's property when you're not supposed to be. It also can be that there was damage to someone or something, and it's a way to downgrade aggravated assault. But before I want to share your concern, Mr. Peoples, why is it criminal trespass rather than disorderly conduct?
That's what I put on my notes. Your Honor, I apologize. And that is actually that would be the correct reduction.
The disorderly conduct?
That's correct.
Okay, I heard you mention that in passing to Mr. Bastian, and I think that fits better and would explain why Ms. Smith was a little confused about like, wait a minute, this was in my space, not his. So let me clarify for you, Ms. Smith, what I understand is going to happen. If we continue with the plea, which we're partway through, you would be pleading guilty to disorderly conduct, which is a misdemeanor. That would be a reduction from the felony of aggravated assault, and the state would dismiss or null pros the false statements. Is that your understanding of what we're doing?
Yes.
Great. Let's keep doing that.
Thank you, Your Honor. And it would be disorderly conduct under OCGA 16-11-39. Ms. Smith, do you understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and run those sentences consecutively or one after the other?
Yes, I understand.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty?
Yes.
Thank you. Do you understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Are you a citizen of the United States?
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, the right to appeal, and the right to appeal if convicted of these charges after a trial. You understand all these rights?
Yes, I understand.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of disorderly conduct?
Guilty.
I'm so sorry, you went out.
She said guilty.
She said guilty.
Thank you. Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
I'm sorry, can you repeat that?
Do you understand that unless counsel is substituted or permitted to withdraw, that defense counsel, that your attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes.
You understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Do you understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes.
Do you understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself?
Yes.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on Monday, June 7th of 2021, law enforcement was dispatched to 710 Eloise Court Southeast, Eloise, E-L-O-I-S-E, in Fulton County. And upon arrival, they spoke with the caller, Miss LaShondra Smith, who stated that her vehicle was damaged by the father of her child, Mr. Javorius Carter. Carter, common spelling, Javorius, J-A-V-O-R-I-U-S. They asked Miss Carter if she observed Mr. Carter damage the vehicle, to which she replied, "We all saw," referring to the other people in the apartment complex. Law enforcement observed the front windshield of the vehicle to be smashed. The vehicle had prints on the hood. They asked Ms. Smith what happened prior to the damage. She advised that she had an active TPO against Mr. Carter. She advised that she came to her mother's home at that address and discovered Mr. Carter had been invited by her brother. They began to argue about taking care of his child, resulting in Mr. Carter being asked to leave. And she provided, Ms. Smith advised that around 23:30 hours, she was ready to go home, but discovered that her vehicle had been damaged. And that's why she had contacted the police. The law enforcement observed Mr. Carter had a red stain on his pants on his left knee and dried blood on his lip and a laceration to his left hand and wrist. And when they inquired how he obtained those injuries, he stated that Ms. Smith had attempted to run him over. Counsel, do you stipulate there's a factual basis for this plea?
Yes, I do.
And Your Honor, the state's asking to reduce because we have been unable to speak to Mr. Carter. There have been several attempts since January, and we haven't been able to contact or find our victim in this case, and we believe that it is a equitable resolution to this case.
Okay. Appreciate you sharing all that. Let me see. Miss Jackson, good morning.
Good morning, Your Honor.
How are you today?
Great, how are you?
I'm well. Can you share with me, please, what criminal history information you've got for Ms. Smith?
Ms. Smith does not have any prior arrests on file, Your Honor.
Okay, thank you so much. Mr. Bastian, anything you want to add on behalf of Ms. Smith?
Yes, I mean, Ms. Smith, we've spoken a couple of times, Your Honor, and that's not the type of person that she is, Your Honor. Obviously, there's things between him and her and the victim on this case, but she's never been in trouble before, and she just, whatever happened on that night, and there were other things, including the victim that was supposedly charged also, Your Honor, and this is just a good resolution.
Okay. Ms. Smith, I've got a couple questions for you, if you don't mind. You have a child with Mr. Carter, is that correct?
Yes, Judge.
One or more than one?
Only one.
And what is your child's name with Mr. Carter?
Harmony Carter Smith.
Harmony?
Yes, sir.
Okay. Does Harmony stay with you or with Mr. Carter?
She lives with me.
Okay. And is Mr. Carter active in her life or not?
Well, I drops her off with my mom's and he goes over there to see her.
Okay. But you and Mr. Carter stay apart. So when
Right.
he wants to see Harmony, that happens through your mom.
Yes, correct.
Okay. And it sounds like that's safer for you to do it that way.
Yes, it is. It keeps a lot of confusion down.
Sure. Do you still have a TPO against Mr. Carter?
I do for DeKalb County. The one for Atlanta has expired.
Okay. Do you work?
Yes, of course. I still work from my work at home job.
And what is that?
It will be Encompass.
What does that mean you do?
I sell parts and things, appliance parts, washer dryer replacement parts, remote controls replacement parts, things in that sort.
Okay. And you do that through a computer or whatnot at your place?
Yes, that's correct.
Okay, great. So Harmony stays with you. She sees her father, but that's through your mom. When's the last time you had any contact, as in you were in the same space with Mr. Carter?
I want to say like May.
And what was the
He
context?
wanted to come to the birthday, but he wasn't able to because of work. But I think it's May.
Okay.
My mom do more of the talking for me with him than I do.
Okay, but when you have contact with him, that's in connection with Harmony.
Right.
Okay, got it. Okay. Do you have any questions for me, Ms. Smith?
Yes, Judge. My concerns were with my probation, with me working and stuff. I wanted to know if I could do it have to be report or non-report?
So I'm actually going to give you a slightly different sentence. So that's a good question, but I don't think you're going to need to worry about that. Okay.
Okay.
All right. Do you have any other questions?
No, sir.
All right. Well, Ms. Smith, it sounds like June 7th of 2021 was a little tumultuous, and that your car got beat up pretty bad, and Mr. Carter may have had a little something happen to him as well. I'm pleased to hear that you have structured things so that he can see Harmony, but he stays out of your way, because it sounds like that had become a not real healthy relationship. And so there's a buffer in there in the form of your mom. But I do find that there's a factual basis for a plea to disorderly conduct, which is the only thing you're pleading to, which is a misdemeanor. I also find that your plea is knowing and voluntary. That means you've understood what we're doing, and no one's forcing you to go forward in this way. You're not super enthusiastic about it, but you are ready to put this behind you. Is that a fair statement?
Yes, sir, it is.
Okay, then I'm going to accept your plea. And what I'm going to do is sentence you to 12 months, but I'm going to suspend those 12 months, which means you are not under supervision. But what it does mean is that, and I'm making this up, this is just hypothetical. 3 months from now, if the police come and you've busted something of Mr. Carter's, or he's able to show, because everyone films everything now on their cell phones, that you smacked him or something like that, not only would you have new charges because of what happened, but the state could seek to revoke your suspended sentence. So for 12 months, I mean, you want to stay out of trouble anyway. You're 29, you're working and all that stuff. But should you get in trouble over the next 12 months, not only would you have new charges, but the state could seek to reinstate your suspended sentence and turn it into either probation or actually you go into jail. I've got a sneaking suspicion, since you've never been arrested other than this, that you're going to have no trouble staying out of trouble. And as long as that's true, then this is sort of like what you asked about. It's kind of like being on probation, but you don't report. There's no supervision. It does mean that you won't have to take this anger management class, but this is sort of like your second chance. This was your one arrest. And if it doesn't happen again, that strikes me as a fair way to resolve what was a complicated situation. Do you have any questions about what I just said?
No, Judge. Thank you.
Mr. Peoples, anything else on behalf of the state?
No, Your Honor.
I appreciate you looking deeper into the case and coming up with a reasonable resolution beyond aggravated assault. Mr. Bastian, anything else on behalf of Ms. Smith?
No, Your Honor. We thank you, Your Honor.
Okay, Ms. Smith, you are free to go. You don't need to report. You're probably going to want to get a copy of your sentence from Mr. Bastian. That'll be available electronically to him later today or tomorrow. So just reach out to him and he can get you a copy of that. Okay.
Okay, sounds good. I'll probably reach out tomorrow to give time.
All
Yeah,
right.
Miss- I'll call you tomorrow.
Okay, sounds good. Thank you, Judge.
All right. You should go. Bye.
Thank you, Mr. Bastian.
Thank you, Your Honor.
You're welcome.
Now, Mr. Bastian, you said you've got one other, and that's Miss Sanders.
That's correct, Your Honor. And Miss Sanders' case, she is there. I seen her. I don't think Mr. Peoples just advised me that I think he still has a little bit of work to do. I think we're almost done on that one. You could tell you could address the court, Mr. Peoples.
Okay, before we do that, let me pause because I sent a text, a chat, but it didn't get through. Ms. Hanson? Good morning.
Good morning, Your Honor. I was just going to look at that chat.
Okay. Well, I'll tell you now, we did have one Spanish speaking defendant, but he will not be coming out into court today. So his lawyer waived arraignment on his behalf. And so I don't know if he was brought over, but if he was, he's not coming out. So you are free to go, but we appreciate you dialing in.
Absolutely, Your Honor. You have a great day. Thank
You too. Bye-bye. Okay, let's pivot back to Ms. Sanders. So we may not need to take anything down. Mr. Peoples, why don't you tell me is Ms. Sanders someone who's got two cases and this is her other case, or is this her only case?
This is her only case to my knowledge, Your Honor.
Okay.
I think she just, at some point she was on two separate calendars from what I was seeing. I'm not sure why. But I've been speaking and been in contact with Attorney Bastian, and I believe we're close to a resolution. What he's asking for, I've attempted through last week to make contact with my victims, and there's a couple other avenues that I want to exhaust before I feel comfortable moving forward. But I think we're very close. I'd ask that we just place this on a separate calendar because I'd like to make another attempt at speaking with the victim because there are minor children involved here.
I remember this case now. This is the one with Mr. Polio, who's already resolved it, and the alleged victim is a defendant in the case. This was one of the classic DA indictments where they indicted both the defendants and the victim all in the same case, which always complicates things for the lawyers. So this is a serious case, and it does need attention. I'm going to move it to a trial calendar, but what I will do is keep Ms. Sanders's final plea rights intact. What that means, Ms. Sanders, is that if between now and your trial date, you and Mr. Bastian work something out with the state or get close enough to it that you want to enter a plea, you'll have the ability to withdraw your plea if I sentence you to something more than what Mr. Bastian asks for. That's what today was supposed to be about, but it sounds like there's a little more work that Mr. Peoples wants to do to see if he can get to a place where the case could be worked out. It's an older case. The other people named in the indictment have already resolved their part of it, and it is high time that we resolve this one. So I will move this to our next trial calendar, but preserve your final plea rights. Do you have any questions about what I just said, Ms. Sanders?
No.
Mr. Bastian, anything else on behalf of Ms. Sanders?
No, Ms. Sanders, we're just trying to get the resolution that we all needed. That's all. That's what we're trying to do. Okay.
Okay, so will you be able to call me after we get off or about
Yes,
a meeting or something?
I will.
Does Mr. Bastian have your phone number, Ms. Sanders?
Yes.
Okay. What are the last four digits of the number you're going to call, Mr. Bastian? I just want to make sure you two can connect.
Oh, very, very well, John. 3699. Okay.
Correct. Yeah, that's
Give me
correct.
about 2 hours. Okay.
Okay.
All right. So, Mr. Peoples, we'll move this to a trial calendar, and either you and Mr. Bastian will work it out, or you will leave copious notes for your successor so that we don't have to reinvent the wheel on this.
Yes, Your Honor. I think it'll resolve before I move to a different unit.
Okay. Sounds good. Ms. Sanders, you are free to go. Oh, hold on. I just got a note. This is on a trial calendar. It is on the trial calendar.
For the 16th.
Yeah. So get working. It's on the trial calendar that we're calling, I think, next Wednesday. The trials aren't till the week of the 21st and the 28th. So yes, it will resolve or be tried on your watch, Mr. Peoples. So important that Mr. Bastian and Ms. Sanders speak today, because I will see all of you again on the 16th if the case has not been resolved before then. And Ms. Sanders, you will need to show up in person, not virtually, but you'll need to be here in court on the 16th for the call of the trial calendar. Okay?
Okay. Okay, I'll be there.
Great. Thank you.
Thank you, Your Honor.
Thank you.
Those are my only cases, Your Honor. Can I be excused?
Yes, sir. Thanks for being here. Thank you, Ms. Sanders.
You're welcome.
You're welcome. Y'all have a good one.
That was a loud phone. All right. Having all sorts of trouble with, it doesn't sound like Monday will come today. The jail is saying still COVID. Vaughn, they're still trying to find. So I have asked Ms. Nelson, I may get involved when it is break time, because that's not okay that they can't find him.
Judge McBurney, just to let you know, FYI, position 2 on the plea and arraignment calendar is here, is present in court, and also position 5 on the plea and arraignment calendar is present in court.
Fantastic. Well, we'll handle those in a sec. Let's get poor Mr. Peoples off the spotlight there.
Young lady, right, what's your name now? What's her name? I didn't see her on the calendar. She said Deputy Gordon took care of her. I didn't see her out of the calendar.
Okay, we'll figure that out too. Ms. Feely, is there anything of yours that we ought to try to tackle before you have to leave?
No, I don't think so.
Okay. Mr. Abate, were you here for the Rognald Charles case?
Yes, Judge.
Okay. I'm not seeing Mr. Charles.
I'm here.
You're not here in my courtroom on a murder charge.
I was told Zoom. I was told I was supposed to report to you on Zoom.
Okay.
In New York, I was told by my attorney that I was approved to be here on Zoom.
Okay. And who would your attorney be? I don't see Mr. Apt. I know they're not.
Jay Apt. He had I think he had a federal case today, and he had to report to the federal case.
Okay. Ms. Nelson, do you have any update from Mr. Apt?
I believe that's correct, Judge.
Was Mr. Apt going to come later today, or was he booked all day with the federal case?
I'm checking, Judge.
Okay. So, Mr. Charles, if Mr. Apt is stuck in federal court for now, you don't need to stay on the call. But if he's able to join us later, we will need you to dial back in. We need to do two things in your case. There's a bond, a motion to modify a bond. Apparently, you had a curfew of 9 to 9 for a bunch of years now, and Mr. Apt is asking that that be modified. And checking to see if he filed a waiver of arraignment. No, we got to do your arraignment as well. You know, these allegations date from many years ago. The indictment is recent and we need to move it forward. So, but we need, oh, hold on a second. His entry of appearance says waiver of arraignment in it, but it's buried way in there.
Again, man, it's my phone to the end of the day. So let me know. I'm gonna keep it to the end of my day.
Okay, it looks like your lawyer waived arraignment for you in something that he filed about a month ago. So really what we need to talk about is bond modification, which is something you want. So we'll try to find Mr. Apt, but you should be motivated to try to find him as well. We'll be on this Zoom session all day long. So if Mr. Apt is available, we'll see you later, Ms. Feely. If he's available, I'm making it up, but at 3 o'clock, then we can do this at 3 o'clock to talk about the bond situation. Okay.
Okay.
All right. So what I'm going to do is you can turn the video off again. And when I hear back from Ms. Nelson, if she has any more information about whether Mr. Apt might be available later, then we could just agree on a time when you dial back in. Please don't sign off until we either say we're not going to be able to do it today, and then we'll do it virtually a different day, or we settle on a time later today. Okay?
Understand.
All right.
Judge, can I be excused to go down to Judge Dempsey's courtroom?
Yes, good luck with that. And we'll just keep you posted. Obviously, we won't do the modification until you're done with the Kenneth Simpson thing, if Mr. Apt is available later today.
Okay, I'll just come to the courtroom as soon as I'm done with this immunity motion.
Okay, good luck.
Thanks, Judge.
All right. Well, let's go through the calendar in an orderly way and see what we've got. So position 1 is Mr. Mundy. He will not be produced today. If anyone was on the call for Mr. Mundy, still displaying some COVID symptoms. COVID reset. Abdullah Sabri. All right. Ms. Wood, is Mr. Sabri, I don't know if Ms. Collins is someone from your office.
She is, Judge, and I will be waiving his arraignment today and interviewing my guilty, but I do need to speak with him and get a good number and all that good stuff.
Okay. And will this be your case or Ms. Feely's?
Fine.
All right. So Mr. Sabri, am I pronouncing your name correctly? Ms. Wood is going to be your lawyer. You and she need to talk some, so don't leave until she connects with you, but I'll be soon. By waiving arraignment on your behalf, she's simply entering a plea of not guilty for you. You're charged with burglary. Let me take a quick look at your bond. You just make sure you give Ms. Wood all your good contact information and get good contact information from her. You want to be easy to find for her. We'll be sending notices for court for you. Usually they go through, but you're going to want to make sure that Ms. Wood can track you down too to let you know when to come to court next. The address we've got for you is an apartment on Quails Lake Village Lane.
Actually, it's changed.
Okay, well, another reason you two should talk. We've got a change of address form and Ms. Wood will fill that out for you. But right now, every time we need you to come to court, we're mailing something to Quails Lake Village Lane. And it sounds like that's not the right spot. The other thing I wanted to talk to you about was bond. I don't know. This doesn't say anything about bond. How'd you get out of jail? It would have been in May of last year.
But the previous judge, she had waived the whole thing, dropped the case.
Yeah, it looks like the charge was dismissed. Okay, so then this is what we call a direct indictment. I guess, Mr. Peoples, you and Ms. Wood should talk about how you want to manage that, because that means that Mr. Sabri doesn't have a bond, which isn't how the process is supposed to work. So he's just sort of hanging out in that way. But I'll leave that up to you all. Mr. Sabri, just make sure you connect with Ms. Wood about that new address and contact information before you go. All right, so waive and scheduling order. All right, Mr. Charles, we talked about, we're going to figure out Mr. App's situation. How about Marcus Jackson? He is not in court. He has a bond. Mr. Peoples, is this your case?
It would be, Your Honor, and the time being 9:51, the state would ask for a bench warrant and bond forfeiture.
Okay, let me take a quick look. It's a serious charge, but I want to see. It is an indictment that came 2.5 years after the incident. He got his bond in December of 2020. And he's not supposed to be driving. Let's look at this. Okay. If you will work with Ms. Nelson on the bench warrant, we'll do that, given the charges.
Thank you, Your Honor.
Sure. Joseph Bagwell. Hey, Mr. Bagwell. Ms. Wood, will this be your office's case?
Yes, sir. It'll be Ms. Feely's. I will waive arraignment and interview not guilty, but if he could stick around so I can speak with him as well.
Sure. So, Mr. Bagwell, you heard what I was saying to Mr. Sabri, similar situation. Ms. Wood's partner, law partner, who just had to leave to go deal with another hearing, will be your lawyer. Ms. Wood will get your contact information and give you contact information for Ms. Feely, her colleague. We will figure out how best to move your case forward. Ms. Willingham, is this your case?
Yes, Your Honor, it is.
All right, so you'll get discovery to Ms. Feely.
Yes, Judge. Ms. Feely will have discovery and an offer actually by the end of today. I was just waiting to find out whose case it was.
Sure. I'm just looking at the right. Mr. Bagwell, the address we have for you is on Ben Hill Road.
Yes, sir. That's my mailing address. I know I need to fill out a change of address form.
Well, where do you get your mail?
That's why I get my mail.
Then that's the address we want, because this is for getting mail to you. Who is at that address?
My stepfather and my brother.
And is that a reliable place for the mail to go? Okay. You are required to live at an address in Union City.
I talked to my attorney, my previous attorney, I guess, about the change of address. I moved back in. What did we move in? I moved in May. I had actually detailed to talk to my Natalie Fiacco.
Sure.
She told me that as long as I was there and following my guidelines, that I was okay.
Okay. What's the last name of the young lady sitting next to you?
This is Crystal Tanner.
Okay, not Ms. Burnett, because you need to stay away from Ms. Burnett.
Yes, sir.
Okay, and that's still happening?
Definitely.
Okay. So Ms. Wood, if you just let Ms. Feely know we need to navigate this address situation. It's not a bond issue if we clear it up, but the bond order was that Mr. Bagwell reside at an address in Union City. It sounds like he's not there. He's also not living at the address that's in the system. I want the mail to get to him, but we also, he's not subject to pretrial supervision. So they're not worried that he's moved, but we just want to make sure he's compliant. Also says a curfew unless he's working and whatnot. I want to make sure that is still working for him. Ms. Willingham, anything from the state as to Mr. Bagwell?
Nothing, Your Honor.
Okay, thanks for getting that discovery out. So Mr. Bagwell, sit tight. Ms. Wood's going to get that information from you and then you can go. All right, Mr. Salmaron, his lawyer has waived arraignment and Mr. Shapiro has provided all the info. So we'll skip over that. If Mr. Salmaron is here, he can go. Well, you can take him back down. We took care of Ms. Smith. Ms. Sanders didn't want to work her case out today. Daryl Lowe. Did you all bring Daryl Lowe over? Ms. Nelson, what do we know about Mr. Francis being able to join us?
I can reach out to him. He did waive arraignment, I do believe, and did an entry of appearance.
I don't think arraignment is what needs. I mean, this is a case from 2010, and we were about to try it when the public defender's office decided 10 years in that they had a conflict.
Yes, I understood. I thought that was a little unusual.
Yeah, that's all right. He can doubly waive arraignment. I guess we need to specially set, that's what it would be called, an inquiry. So we get Mr. Francis here. Is Mr. Lowe up?
Yes.
Okay, I'll say hi to him in a minute. How about William Hill? Is he here? Why is he not here? I think Ms. Carnage is on. She has been patiently waiting. She was on. She is
I'm here,
still
Your
on.
Honor.
Hey, Ms. Carnage, how are you?
Good morning. I'm good. How are you?
I'm well. Hold on one second. We're trying to figure out, will Mr. Hill be making it here? Okay. Ms. Carnage, Mr. Hill will be here. He's apparently at the city jail rather than the county jail, and that's apparently a different transportation system. So I don't know if you want to, you've got other things you need to do. Do we have an ETA for?
We can get one, Judge.
Okay. If you just hold on, Ms. Carnage, we'll get an ETA for Mr. Hill. And then if you want to step away and come back when we know he's going to be here, that would be fine. I'm anxious to try to move his case along. I don't know if you've had a chance to connect with him yet, but at a minimum, I want him to see you and you to see him, at least virtually.
Yes, sir. Well, I hope he got my letter because I sent it to the county jail, so I didn't. Anyway, okay.
We'll see, but just sit tight. We're going to figure out when he's going to make landfall, since the city jail is like 1 block from here. Hopefully he'll be here soon. And we'll at least have the first connection with you and Mr. Peoples and Mr. Hill. Okay.
Okay, thank you.
Thank you. Robert Daniels. Okay. Ms. Wood, will you be handling his cases?
Yes, Judge, all 3 will be mine. If we come back to him, Mr. Peoples and I are trying to resolve these today.
Okay. I'm familiar with Mr. Daniels just through drug court. So happy to work through those. He requested that his cases stay with me rather than go to Rouse. When you're terminated, you get a chance to say no mas to your drug court judge, but he did not do that. And then the last position on this first calendar is Ms. Culpepper. Is she here and up? Okay. And we're having a bond hearing.
We're also trying to work this out today.
Do you want a little more time to speak with whomever you need to speak with? Okay. So I know your name is not Juicy, but there's an entry that's Juicy. It sounds like we may be resolving your sister's case this morning. Her lawyer needs to talk with the prosecutor a little bit more. Since it's 10, why don't we see if there are things on the 10 o'clock calendar we can, Mr. Hill is here.
Just got here about 10 minutes ago.
Is he up or is perfect?
We have to go get him.
Okay.
He's downstairs.
Why don't we do this that way? Because we've got Ms. Carnage on. I'll step off the bench. Or is there someone else I'll step off the bench. Ms. Wood can talk with the 2 folks she needs to get info from so they can go. You guys will have a chance to bring Mr. Hill up so that we can work with Ms. Carnage and then she can be on her way. And then we'll work with the other cases. Anyone else here? Ma'am, what?
She's here for Mr. Daniels, who's in custody. Young lady right there, that's his
Great.
mother.
Excellent. We're going to work on Mr. Daniels' cases. His lawyer is right there. And ma'am, what case were you here for?
I couldn't find her on the calendar.
Are you here for Mr. Vaughn? No,
She's here for herself.
Okay. Why don't you chat with her too during this break we're going to have. And when I get back, we will at a minimum deal with Mr. Hill, whatever that dealing is going to be. And then we'll talk about some of these other cases. And again, Mr. Sabri and Mr. Bagwell, once you give your information to Ms. Wood, you guys are free to go. Thanks. All right. I'll be back. Mr. Bethea, he's on the 10 o'clock.
Just walk. You here for yourself or somebody in custody?
Judge McBurney,
Yes, Ms. Nelson.
they have located Vaughn and he should be transported shortly.
Excellent. Are you able to handle the Vaughn matter if Ms. Feely is not here?
absolutely.
You are versatile. All right.
We get you in the wrong courtroom. We get you straight up.
He's a defendant in this courtroom, but he's not here.
Who's that?
Jay Dunn.
I don't think Mr. Dunning was on the calendar today. Ms. Sellers, did you have Jay Dunning on your calendar? Okay, well, let me look it up and we'll see what this is.
I'll double check that. I was here for Carolyn Tidwell.
Yep, and she's on the 10 o'clock. So we're gonna talk about Ms. Tidwell. We're just taking a little break before then to process a few things.
Got it.
Please. Yeah, go do your things. It does say August 8th, Jay Dunning inquiry. So you are in the right place, but for some reason, it's not on the physical calendar. So don't go anywhere. Let's see if we can get an update for you. Ms. Wood is the lawyer for Mr. Dunning. You know, we're working through competency issues for Mr. Dunning, but we'll talk about that. I'll tell you that he's not here because he didn't make it onto the printed calendar. Ms. Nelson, do you have any insight as to that? Your entry, and this is just what's in Odyssey, says August 8th, inquiry, 10 a.m., please transport. So this was bring Dunning this time.
And I'm not sure why he didn't print out on the calendar, Judge. I'll have to double check on that one.
Okay, all right. So we'll figure that one out, but that may have been an administrative error on the court side. You are in the right place at the right time. Okay, thanks. All right, I will be back in how much time you need to get Hill up? How about you just come get me? I'll give you the time you need and then you come get me. Thanks. I'll make sure my kid is awake. Ms. Willingham, are you still on the call?
I am, Judge.
I have the material witness document. It's what I'm waving in my hand here that I've signed. Should I give it to Mr. Abate when he shows up, or do you want me to just leave it in my office? I don't know if you're allowed in the office this year.
I will be there tomorrow. I will physically be in the building tomorrow. So either way, if you give it to Mr. Abate, I'll get it from him tomorrow. That's fine. Or I can just come get it from you tomorrow.
Let's do it that way. Why don't you come get it from me tomorrow? I'll be doing drug court all morning. So why don't you just come to 8D and I'll leave it out here on my bench, okay?
Okay, thank you.
Thanks. Okay, I'm leaving.
Is Attorney Wood still in the courtroom? Or did she step in the back?
I think she's in the back.
She's in the back. Okay, thank you. If somebody will let her know I called her.
I'm gonna stay.
Yeah,
We'll bring him out.
Yeah.
We'll bring him out. Look at the attorneys. We'll hear your client.
Hey, Attorney Wood.
Hey,
Hey, I just tried to give you a call.
sorry, I was talking, I didn't have my phone. I'll call you back.
Okay.
I think his attorney is on Zoom.
Okay, thank you.
Daniels? Yeah, so those I'm trying to resolve.
Oh, so you still need to speak?
Well, I haven't talked to Mr. Daniels yet. I've talked to Mr. Peoples about mistakes.
So, okay, here, no, not here.
No, Daniels. Robert Daniels.
Well, on the water, man, see it. Let's move to the step to the back.
Okay. Can you tell me your name?
Strotter.
How do you spell that last name?
Strougher.
So like Slaughter, but TR, Strotter. Okay. And you've got a case? You think? You know. You know. Okay. You have two. One is in traffic court. You got a speeding ticket.
I tried to pay that and it was never in the system.
Okay. I'm not concerned about traffic court. You've got more serious charges here, and it is assigned to me. Oh, you didn't come to court. Huh. So it's good you're here. We had your plea and arraignment on May 11th, and you didn't show up. And so we put your case on judicial hold, and there's a warrant for you. So we need to work through that today. But don't talk about anything without Ms. Wood in here.
If I may, Your Honor, what's the SC number?
23 SC 186883.
186883.
Yes, sir. But since you don't know how to use Odyssey, how's that going to help?
It just won't allow me to open.
I'm kidding. I understand. I understand. You can look it up.
Thank you.
Do you?
I'm on. If I can pull something for you, let me know and I'll email it to you.
Okay, thank you.
All these people having to help Mr. Peoples to think he's going to a specialized unit. Yikes. So I'm gonna ask you one question. Do you still live on Centennial Olympic Park Drive, or is that an old address?
No, that's current. It's just mail. You have to shorten the address or it's gonna get returned.
Okay, that's probably what happened. But we'll work through that. Ms. Wood will return, and we'll have a discussion about lifting the bench warrant. Okay. Where did Ms. Wood go? Oh, who's she talking to? Okay. Okay. She's got a busy morning. Yeah. Okay. Ms. Nelson, did we learn anything about Mr. Apt's availability?
No, I am reaching out to this office. I have not gotten a response.
Okay. And Juicy has turned into Amber. So that's good. Mr. Hill is here now. Miss Carnage, I don't know if you heard that. Are you still on? Oh, don't tell me you went away. Hopefully she'll get back on. So, ma'am, when Ms. Wood reappears, I'm going to ask about Mr. Dunning. He was supposed to be on the calendar. For some reason, when the calendar was published, he wasn't. And then a new one was published with him on it, but that didn't make it to the sheriff's office, so he was not brought over. So we'll talk with Ms. Wood and Ms. Sellers, who's the prosecutor, about whether there's something that we'd be able to do substantively with Mr. Dunning's case today. And if there is, we'll try to get him here this afternoon. I don't want you to have to wait around if it's more of a discussion about where Mr. Dunning is in terms of being in a position to understand what his charges are and how to resolve them. So we'll have that informal conversation once Ms. Wood comes out. Hey there.
Yes, Judge.
So, couple things. I guess Ms. Nelson, if you can try reaching out to Ms. Carnage to get her to dial back in. We have Mr. Hill here now. Mr. Vaughn is on his way, but isn't here yet. That's our afternoon calendar. So, tell me, Ms. Wood, if you've got an update on Daniels, or if that's one where you need more time.
That one, Judge, this will be a non-negotiated plea. I just need to send maybe one email to Mr. Peoples.
Okay.
About that case. I already talked to Mr. Daniels, so once I send that email, we'll be good to go.
Okay.
And then I also believe we are good to go on Culpepper.
In terms of a plea.
Yes, Judge.
Okay, great. Mr. Dunning is your case, is that correct?
Yes.
So Mr. Dunning, you're related to Mr. Dunning how? Mom. Mr. Dunning's mother's here. Mr. Dunning is not here, but we can get him here if this was going to be today, a date where having Mr. Dunning here and in court was going to advance things. We should still talk about the case because we've got Mom here, and it's on some version of our 10 o'clock calendar, not the one that I printed out, but and we've got Ms. Sellers. So if there's a way we can at least have a status discussion about where we are with Mr. Dunning, and we're going to do the same with Ms. Tidwell, who is here. Tidwell is here.
Judge, I have her since that.
Okay. All right. But let's start with Dunning so that Mr. Dunning's mom knows what's happening. And then we'll go from there. So remind me what the latest is. That I know there was an evaluation, and the results are that we can move forward, or that Mr. Dunning is in that long line to get to Georgia Regional.
So Judge, this is the one where Dr. Schwenke's response to me was that he is trying really hard and making good progress, but he's
At restoration at the jail.
Yes,
Okay.
he's not there yet.
Okay.
And that was on July the 5th, that I got that update, and I have not been able to link up with her since then. She told me she's very short-staffed.
Is Dr. Schwenke the one who is leaving?
Yes.
Also, so short-staffed and then not going to be working for Emory Grady anymore?
I think that is correct, if I remember correctly.
Okay. Well, I can work through Vicki Roberts to see if we need to get someone else assigned. I don't know how that works.
And there's another, Miss Brown, that I've talked to as well. So I don't know if I can send an email today. And I know Miss Patterson is also involved.
How do you spell Schwenke?
SCHWENKE.
Okay. And your recollection is that Dr. Schwenke said that Mr. Dunning is doing well in the restoration pod, but in her professional opinion, had not been sufficiently restored.
Correct. I'm
Okay.
looking at her last email, and I believe they're still making adjustments to his medication.
Okay. And then you said the other person you're working with is a Ms. Brown, Dr. Brown?
Ms. Brown, Joyce Brown.
Okay. And that's someone who is associated with the restoration pod?
Yes.
Okay.
Pretty sure I got these from Ms. Roberts.
Okay.
She referred me to these two.
Got it. Ms. Sellers, do you have any other information about Mr. Dunning?
No, Your Honor, I don't. And I think maybe part of the challenge of that is I see that there was a special plea of incompetency that was filed back in December, but there was never an order that was officially finding that the defendant was found by the court to be incompetent to stand trial.
So that's on me. I'm not pushing back at all, but I see that there is
having that order in place is what triggers the state being able to follow up.
Got it. And actually, I feel a little better now. I'm happy to enter an order. That actually was all in CP land. And you should know, this is a side note, but this is important for Ms. Sellers in particular. Our bench's case management committee will be talking today about getting a judge to own CP cases where there's been a finding of not competent.
Okay.
Because this is an example of one falling through the cracks, where a lawyer representing Mr. Dunning says there's a concern and there's this special plea, but there's not a judge, there's not a magistrate who follows CP cases. And so we're going to be brainstorming about whether we're going to handle it sort of like we do for bonds for the 7 deadlies. If you are arrested for murder, we don't let the magistrates hear those bond hearings. Those have to go in front of the presiding judge.
Yes.
Superior Court judge, and then that judge keeps that unindicted case for purposes of bond until it's an indicted. I think we're going to pitch the same model. Judge Ingram or I or both of us will let you know what we develop. The whole bench will have to approve that in the end, TBD. But Mr. Dunning's case is an example of one of those that I'll bring up today at our meeting. Where it would have been helpful, not essential, but helpful to get an order, which would have come from the presiding judge who followed the case if we had that policy in place.
Thank you for that, Judge.
Sure. What I'll do is reach out to Ms. Roberts and see if there's something I could enter that would increase the focus and attention on Mr. Dunning, although it sounds like he's getting it. And then he may just sort of be stuck because of some professional transitions that are occurring as well. But what I'll make my job would be to reach out to Ms. Roberts, and she may echo only what you already have, but maybe a nudge about Dr. Schwenke and getting back to you would be helpful. So your sense is from those folks that we need to continue to focus on restoring Mr. Dunning before you'd be and he'd be in a position to work through the aggravated assault charge.
Yes, Judge.
Okay. Got that. Ma'am, do you have any questions about what we were just discussing?
I'll talk.
Oh, you guys will talk. Okay. Bornaza Dunning is who? His father? Okay. That's the alleged victim in the case. Got it. So it's a family situation through and through. All right. All right. Did I pronounce the first name correctly? Bornaza. Was Bornaza injured or just shot at? Like it actually hit him. Okay.
Hey, Judge, I've been in contact with him. He just wants Mr. Dunning to get the appropriate help. So
Sure.
on board.
Okay. It's often helpful when it's all within the same family. I mean, it's tragic, but it's helpful because people understand rather than fear. And so we'll keep working on that. You can understand why the state is taking this seriously because one, Bornaza could have died. That's often what happens when you get shot. But two, it could be someone who doesn't know and doesn't know necessarily how to react to Mr. Dunning, and then it could be fatal for Mr. Dunning because people shoot back when they get shot. So we'll continue to be sensitive about this. I'm sorry you came and didn't see your son, but it sounds like producing him today wouldn't have advanced a whole lot of this. So why don't you talk with Ms. Wood when there's the next break, and I'll reach out to the folks who are managing the restoration pod to see when we ought to reset this. Ms. Sellers, anything else you want to add as to Mr. Dunning?
No, Your Honor.
Okay. All right. 23 SC 186 302. All right, great. Got it. Let's do one other quick thing. I think we've got Mr. Peoples on. Seated behind you is Ms. Strotter. And she missed her arraignment in this case. Let's work through the bench warrant situation. Ms. Strotter, why don't you come sit with Ms. Wood? Mr. Peoples, did you have a chance to look up Ms. Strotter's case?
I did, Your Honor, and I can see it. I see that it's on judicial hold, and she was on for plea and arraignment May 11th of 2023.
Right. So she's got a bond. It says you're supposed to stay away from an address on West Peachtree and a Ms. McClure. You've been staying away from Ms. McClure? Okay. Is that a family member, an acquaintance? Ex. Okay. Keep staying away from Ms. McClure. Mr. Peoples, I'll start with you. Do you want to do a little more research? Do you have any objection, assuming I think we've got the correct address for Ms. Strotter. We may need to truncate it a little bit. She said something about if you put too many words in, it doesn't get delivered to her, but she's here now. She showed up voluntarily. She qualifies for your office? Yes. It's a fancy sounding address. Okay. Do you have any objection, Mr. Peoples, to lifting the bench warrant?
No, Your Honor.
Okay. Why don't we do that? What I'd ask you to do, Ms. Strotter, is one, make sure Ms. Wood has all your contact information. So not just a mailing address, but phone, email, your X or Twitter handle, whatever it is. But also tell us what we should put on things that get sent to you so they get there. I'm not going to read it into there's no record being made right now, but it says Centennial Olympic Park Drive, and then there's a unit number. What are we not supposed to include?
You have to shorten it. It has to be like St. Ali Park.
How about you write out what it needs to be, and also maybe we can get an email address for you in the system as well. But most of all, if Ms. Wood has your contact information, she will be reaching out, or Ms. Feely, whoever's got your case. Hold on one second. Hello. Hey, how are you? Sorry, I'm single parenting and I got a little guy at home, so I did answer that. But he made his own breakfast. So that's what Cinnamon Toast Crunch will do. All right, so you've got good contact information for Ms. Strotter, and Ms. Strotter, You have a way to reach Ms. Wood? Okay, all right. Then we'll lift the bench warrant. Is Ms. Strotter waiving arraignment?
Yes.
Great. What will happen next? Ms. Willingham, is this your case? I was asking Mr. Peoples his thoughts about this, but now that I understand the nature of how Ms. Strotter is allegedly connected to the alleged victim, is this your case or will it stay with Mr. Peoples?
Your Honor, looking at it in Odyssey, it says that it's assigned to the complex trial division, so it says it's mine.
Okay, that's fine. You guys will sort that out anyway. And Ms. Strotter needs to worry about her lawyer, not the prosecutor. So she's going to waive arraignment. Mr. Peoples, I'm going to rely on you then to get discovery to Ms. Wood so we can move this forward because we'll get a scheduling order entered.
Understood, Your Honor.
All right, great. Do you have any questions, Ms. Strotter? How'd you know to come to court today?
I totally forgot, Judge, that I told her to walk in today. She actually reached out to me in early July when she realized she'd missed. We were in the midst of trial, and I think this was like the first calendar I saw.
How did you realize you missed court?
Because I check up on the website every now and then, and I just happened to check, and I was like,
Uh-oh. Uh-oh. Okay. All right. All is good. Don't miss again. This is your one free pass. And I appreciate Mr. Peoples being flexible. It was the right answer here. What will happen next is Ms. Wood's going to get the discovery in the case. So if there are police reports or body cam footage or who knows what, she'll spend time with you on that and then let me know if there are any motions. And if there are no motions, then we'll move your case towards trial. That doesn't mean you have to have a trial, but I put it on a trial calendar because that makes the defense attorney and the prosecutor get serious about seeing if there's a way to work the case out. Your role is to, one, follow the conditions of your bond. So stay away from that address and that person. And two, stay in touch with your lawyer. All right. All right. Thank you. If Ms. Wood says you can go, you're free to go. Yep. All right. What would you like to do next? Do you want to talk a little bit with Ms. Culpepper? Do you want to talk with Mr. Peoples about Mr. Daniels? I can go away for a few minutes.
Judge, we could, I can't remember if we finished talking about Ms. Tidwell.
We didn't start. So we could do Tidwell. You tell me, since you're having to juggle all this, the order in which you'd like to do it.
I think if we take care of announcements on Mr. Bethea and Ms. Tidwell, then I'll be able to do the pleas.
Okay, let me just write one thing down here. Okay, you want to start with Mr. Bethea?
Yes, and if we could bring him out.
Before he comes out?
Yes.
All right, Mr. Peoples, are you handling the Bethea matter right now, or is that Ms. Sellers?
Your Honor, that would be Ms. Sellers.
Is that accurate, Ms. Sellers?
Okay, Your Honor, from my understanding, I did have an opportunity to briefly communicate with Attorney Woods. And it's my understanding that the defendant is now competent. I did receive an updated evaluation as of this morning from Attorney Woods. And so he is now competent to stand trial. The state does believe that there needs to be an order stating that since he was previously found incompetent to stand trial, that there be a ruling that he is now competent.
So you're saying now NOW, not NOT.
Right.
Okay, he's been restored.
Presently, he has been restored. Yes, Your Honor. And
okay.
That is new because I just received that information this morning.
Okay. So Mr. Bethea is here on a probation revocation matter. It's an old case for which he got a bunch of probation. It's a somewhat notorious case. And so I want to make sure we're all thoughtful about how we work through it. Ms. Wood, do you agree I guess you shared it with Ms. Sellers, the current professional assessment is that Mr. Bethea is again competent to move forward with whatever legal proceedings are there.
Yes, Judge, I saw him 2 weeks ago. He's the best I've ever seen him doing.
Okay.
And then Ms. Patterson saw him shortly after I did, and she agreed. The difference now is that up until this point, he's told us, I don't want your help. And when I saw him 2 weeks ago, he said, now I believe I need your help.
Okay.
The program placement. So Ms. Patterson has found, I think, 2 different programs, but of course he hasn't been accepted yet.
Sure.
And she's working hard on that. So
Remind me, if you remember, because we're not doing that today. We'll get Mr. Bethea out in a minute and hopefully have a good connection. What the basis for the revocation would be if either we have a hearing and he's found to be have violated his probation, or there's a stipulation.
if I remember correctly, Judge, he did not report, and then there was a misdemeanor a year ago when he got arrested that he's already taken care of. So I think
Okay.
it's a new misdemeanor arrest.
So technical violation and then a substantive. Was the misdemeanor a crime of violence? I'm not holding you to it, but we can find it.
I think it was a battery.
Okay. All right. But he's pled to that.
Yes.
All right. So you're not ready to go forward with the hearing, but when we do have the revocation hearing, it's an uncontested revocation hearing. So whether it's Ms. Sellers or Mr. Peoples, they don't need witnesses to prove it up. They may want to have witnesses for whatever reason, but they're not going to need to prove up the allegations.
Right.
Helpful to know. Okay. So Ms. Sellers, my thought is we bring Mr. Bethea out and then we talk a little bit about this updated status. I'm happy to enter an order. If you've got a proposed order, a template that you use, if you want to send that to Ms. Nelson and Ms. Wood so she can see it. I agree with you that having that in the docket will be helpful, especially in Mr. Bethea's docket, because he has bounced back and forth between competency because he unfortunately stopped staying on medication and then things get complicated for him. So that'd be great. But why don't we bring him out now? You have him be wherever you want him to be. All right.
Come on.
Hey, Mr. Bethea, if you take a seat right there by Deputy Gordon. Mr. Bethea, it's good to see you again. How you feeling? Good. So I was just chatting with Ms. Wood and the prosecutor who's working on your case right now. I'm going to put her on the screen there. You can see her. That's Ms. Sellers. She's appearing virtually today, but I was getting an update from Ms. Wood, who told me that you're doing a lot better and that you have decided, and I think it's a good decision, that you want to work with Ms. Wood and Ms. Patterson, who's her colleague, who is looking to find a program for you on the outside that will be supportive of your situation. And that Ms. Patterson's working hard to get you accepted into one of those programs. When that's been lined up, we'll have a hearing. The reason why you're locked up right now is because it's alleged, someone says, that you violated your probation in a couple ways. And Ms. Wood and I and Ms. Sellers were just talking about that. But I think the plan is, I want to make sure you're okay with it, is that we'll get you back here soon to have that hearing. The 2 allegations are, number 1, that you stopped reporting to probation. And then number 2, you got a new case. It's now an old case and you've already worked it out. It was a misdemeanor. But we'll need to have a conversation about that. I'll need to hear from Ms. Sellers, the prosecutor, what she thinks the consequences ought to be. And I'll certainly hear from Ms. Wood, and she's already told me what she's going to recommend, which is one of these programs, assuming you get accepted, because that's the kind of program that's designed to keep you safe and healthy and stable, which is, of course, what we want. Any questions about anything that I just described? Okay. I will tell you, you seem to be a lot better. You and I have had a couple conversations where you were mad and saying stuff about things that I wasn't seeing that you were seeing. So whatever you're doing right now with the doctors, I hope you keep up, because it's got you in, it seems like a safer space. I hope you feel that way too. Okay. If you don't have any questions, then I'm going to keep working with Ms. Wood. She's going to let us know when we should get back together again. We'll bring you over here. It won't be one of those things where you're in the booth. I want this to be in person. Hopefully Ms. Sellers will be able to be here in person. Right now, her boss is saying that the lawyers need to be out of the building for a little bit because there's something else that's going on. But soon everyone will be back in the building. We'll get you back in here once you get one of those programs and see if we can move your case forward. Okay. All right. I'll see you soon. Thanks for being here. So how, Ms. Sellers, you'll get to me and to Ms. Wood in the next few days a proposed order, and I'll handle that. In terms of keeping Mr. Bethea on our radar, should we set it out 1 month for inquiry, or do you think that before then you're going to have something locked in, and so we shouldn't set it out at all? I guess as a fail-safe, I want it to be on another inquiry calendar. We can always make it sooner, consistent with Ms. Sellers' schedule and mine.
If we could do 1 month.
Okay.
Then, I know this is high priority for Ms. Patterson. And so if something comes up sooner, I can, Ms. Nelson.
Okay. And yeah, and I flagged that only because if Ms. Patterson gets a placement, they don't always hold those forever. And so that would be a reason to say, hey, tomorrow afternoon, and as long as you're waiving any notice, it just would be making sure we can get some of Ms. Sellers' time. Okay. That takes care of Mr. Bethea. We have Ms. Carnage back on. So I'm wondering if we can shift to Mr. Hill, and then we'll do some other stuff. So can we bring Mr. Oh, okay. We're going to pause. Talk with Mr. Dunning's mom. That's fine. We need LT back out here to get Mr. Hill out. Let me see if there's anything else we can do with no.
James, this is mom. She wanted to speak.
Whose mom?
Mr. James. Robert.
Oh, Mr. Daniel's mom. Okay.
Yes, I was just hoping that he won't go free today. I'm really a witness of the prosecution.
So let's make sure you talk with the prosecutor then.
I did.
Oh, you did. You spoke with Mr. Peoples?
He's on heroin bail. And I have photos, even when Officer Collins came to apprehend him, I have the bed photos, a big old drug pot in the middle of the bed, tons of needles and bands.
Okay.
All that.
He's not well.
So he's not well. He just, if he gets out there, I fear he's going to kill us.
Okay.
And I don't want that.
No one does.
Yeah.
Okay.
So I just beg that if you put him in that RCEP program, because I did speak with the gentleman just yesterday. He graduated from that program and he's never returned to drugs. He says 70%. Chris Austin, I think and he said 70%. It's a 70% success rate. He doesn't need to be in a place and go in and out. Like
Right. Well, that's one of the features of RSAT is you don't get a leave. Right. Yeah. Well, drug court is it's voluntary in the sense that you could quit. There are consequences. But I hear you. Okay. Well, let's make sure that it sounds like you've shared that with Mr. Peoples. Okay. Okay.
Yes, Your Honor.
Okay, great. Hey, Mr. Hill, if you will take a seat right in the middle, right there. Let's get you on the screen, and Ms. Carnage, if you can come online.
Good morning, Mr. Hill.
Good morning.
let's get you, there you are. You're in your mobile office. Excellent. Okay. So let me find Mr. Hill on the calendar here and on the system. Mr. Hill, hold on one second.
I believe it's position 11, Judge.
Yep. I'm just pulling it up on Odyssey. 274. Okay, I was just seeing if when Mr. Hill had Ms. Snyder, if he'd ever been arraigned. It doesn't look like it. So let's do this. Mr. Hill, I'm Judge McBurney. We may have met long ago. I'm not sure. Your case is real old and it was active for a little bit and then we lost track of you. And then we found you and we've struggled to line up an attorney because we had a shortage of attorneys, but Ms. Carnage has very graciously agreed to offer her services. The county is taking care of that for you. And she is now your lawyer. You're charged with burglary. Your co-defendant has already resolved his charges. And I want to make sure we move your case forward. I'm sure you're anxious to get it resolved as well. You've now been in jail for 4+ months. And it's time to make sure things start to happen. Ms. Carnage, I'm going to basically start from scratch. Again, it's possible that Mr. Hill had an arraignment when he had a conflict offender, but the system's not showing that. So I'd like to start by asking you if you're going to waive arraignment on behalf of Mr. Hill.
Yes, Your Honor, with my client's permission, we can waive arraignment.
Okay, and all that means, Mr. Hill, is that I'm not going to read into the record the indictment and tell you all your rights. Ms. Carnage can cover that with you. And by waiving arraignment, you're just right now entering a not guilty plea. It means then that the prosecutor, Mr. Peoples, who we ought to put on the screen too, so you can see him. There he is. He's going to get discovery, which would be police reports or whatever's out there. Get that to Ms. Carnage. And then your lawyer and Mr. Peoples can start talking about what do we do with this case? And more importantly, Ms. Carnage can come see you with a discovery to say, here's what the police had, that you're on video breaking into the house, or you're not on video, or the other guy confessed to it and said you weren't even there. Discovery could be real good news for you, could be real bad news, but it's yours and you need to get it. And that's going to flow through Ms. Carnage. Okay?
Okay.
Ms. Carnage, anything else you want to cover at this time besides waiving arraignment for Mr. Hill?
Your Honor, I would like to get his verified address. I think I sent his mail to the county jail. So if he could give me his address and his inmate number, that would help me get that to him.
Sure. We'll get that from him. And then let's also see, this was back when you were out. There was an address of Vineyard Walk, an apartment. Do you still have family there?
Yes.
Okay, so one way Ms. Carnage can reach people is at that address that's in the system, apartment 5.
Yes.
Okay, that will get to your family. But if she wants to mail stuff to you directly, are you at the city jail or the county jail?
City.
Okay, so you're at ACDC. Do you have a cell number or anything?
Yeah, six Northwest. I think I'm at
6 NW 109. Okay, got it. So Ms. Carnage, subject to change, but right now Mr. Hill is at the city jail, Atlanta City Detention Center, and it is 6 Northwest NW 109.
Okay.
All right. So Mr. Hill, what's going to happen next, as I mentioned, is that the prosecutor is going to get discovery to Ms. Carnage. She'll get it to you. She's going to need to talk with you. So she'll come to the city jail and meet with you, and you guys will figure out a plan how to move forward. I'll see you next, either because your lawyers filed some kind of motion. Maybe you I'm making this up, but maybe you said something to the police and she thinks it should be suppressed. Or she's worked something out with the prosecutor. Then we'll get you back here and take that plea if that's what it's going to be. I'm not saying you need to plea. You may say, let's take this to trial. That'll be the third reason I see you, is either a motion, a plea, or for your trial. And I'm going to try to fast track your case. I need to give Ms. Carnage time to be ready, but you've been in jail for a while and it's an old case. And so we need to move it forward, whether it's a plea or it's a trial. Okay?
Okay.
Any questions about anything I said?
No, sir.
All right, Ms. Carnage, anything else on behalf of Mr. Hill?
Nothing further, Your Honor. I could.
You froze up on
Give it to him. I was going to say I could give Mr. Hill my office number as well, but I come in the letter that I sent to him. It's okay.
Okay.
Unless you would
So
like it, right?
do you want her phone number or are you good?
Yeah, I'll take it right now.
Okay. Ms. Wood, you have something to write on?
Yes, sir.
Okay, we're ready, Ms. Carnage.
Okay, it's 226, what was it? 229 226 2600, and the other phone number is 770 212. I have so many phone numbers, I forgot. Hold on one second. Okay, 770-212-1675.
Excellent.
Thank you.
All right, thank you, Ms. Carnage. Mr. Hill, we'll see you soon with whatever's happening with the case.
And Your Honor, if I may,
Well, hold on one second while I remember. Ms. Carnage, Ms. Nelson may send you our waiver of arraignment form, but there's actual document you'll need to fill out that gets into the record so that we have an official record that Mr. Hill waived his arraignment. So if you were here in court, I'd hand you the form, but you're right where you need to be. So Ms. Nelson may send you that waiver form. If you don't mind filling it out and getting it filed, that would be great.
Okay, and the state has already provided discovery to me. Like I said, I forwarded it to the county jail, but I can forward it to the city jail so Mr. Hill can review that, and I can meet with him and go over it as well.
Excellent. Yeah, the sooner you connect with him, the better, because then you and Mr. Peoples can start talking about the case. And you were going to say something, Mr. Peoples? I interrupted you.
I was, Your Honor, but Attorney Carnage just touched bases on it. Discovery has been provided, and I've actually spoken to Attorney Carnage as well. I would just ask if available, if there's space available on an upcoming calendar, is it possible that we could get Mr. Hill in for a resolution if Ms. Carnage is able to speak to him at some point?
Sure. I mean, we could put him on. I'll work with Ms. Nelson, but calendars need a couple weeks notice, but that's a great sounding request, and we'll try to get Mr. Hill back here in the next few weeks. And as long as Ms. Carnage can fit into her schedule, I know she's got a lot of cases, connecting face to face with Mr. Hill to see if he's interested in whatever you're suggesting, then let's get everyone back here and try to resolve it.
Thank you, Your Honor. I think we'll have a resolution queued up very, very soon.
Sounds good. Thank you.
Thank you, Your Honor. And that concludes my business with the court. May I be excused?
Yes, ma'am. Thanks for your flexibility. It took a little bit to get Mr. Hill here. Appreciate it.
Thank you.
All right. Ms. Sellers, were you here for Mr. Lowe also?
No, Your Honor, I am fairly familiar with that case, but I know that previously that case was being handled by the cold case unit. I can reach out to Mr. Fawcett, Deputy Fawcett, as it relates to.
He doesn't need to hop on. I just was gonna give it, you can relay it to him. Mr. Francis is on leave, so he won't be connecting. I'm gonna bring Mr. Lowe to the door just to say hi to him. And what Mr. Francis had to say was, I'm good to go. Let's put this on a trial calendar, which is what Mr. Francis usually says. So I'll work with Ms. Nelson on what to do with Mr. Lowe.
Yes, Your Honor.
Okay. Mr. Charles. You out there?
Yes, I'm here.
Hey, two things. One, I was reminded that I had said it was fine that you appear via Zoom. So I'm sorry, I was a little snippy about that up front. It's fine that you appear via Zoom. Number two, Mr. Apt and both of his associates are stuck in court in different places. So he has asked that we reset your bond motion. He's already waived arraignment, so we can move the case forward. The prosecutor will get discovery to your lawyer, and then he and you can start talking about it. And then we'll figure out a time to get you back here virtually and Mr. Apt in person to talk about that bond modification, okay?
Okay, thank you so much for your time.
All right, you're free to go.
All right, thank you. Have a good one.
All right, if we can bring Mr. Lowe just to the door, please. Mr. Lowe. Okay. And then Ms. Wood, after that, we can do however you want to order it. Daniels, Tidwell, Culpepper. We'll get.
We could do Tidwell then Culpepper. I think Daniels will probably take a little bit longer than the other two.
Okay. Hello, Mr. Lowe.
Good morning. Good afternoon.
Well, still morning. You got 55 minutes of morning left. I hadn't seen you in a little while. I just want to make sure you understood why you were brought over. I thought your lawyer, Mr. Francis, was going to be able to be here today, but he has a conflict and can't be here. So I didn't want you to think, gosh, you brought me over here for no reason. But I wanted to get an update from him about where he thought we were with your case. You hopefully will remember when Ms. Shubo and Ms. Primovic were working with you. We were pretty close to either going to trial or working the case out. I'm talking about the murder case, not you have a little case as well. Mr. Francis says he's ready to go and we should put your case back on a calendar. So I hope to do that soon. It won't be, the next calendar's already published, but later this year, I hope to get your case on the calendar so we can get it either tried or resolved, whatever it is folks decide they're going to do. Are you taking all the medication you're supposed to be taking? Good. Okay. Well, I wanted you to know why you were brought over today. I was hopeful your lawyer would be here and we'd just talk about next steps. His name is Dennis Francis, Mr. Francis.
I know, talk to him.
Well, I'm gonna make sure he comes talk to you because that was gonna happen today, but he couldn't be here. So I'll make sure he comes to talk to you. All right. All right. You be safe. All right. Good seeing you. All right. Before we bring Ms. Tidwell out, and Ms. Sellers, are you handling Ms. Tidwell?
Yes, Your Honor.
Okay, what are we doing with Ms. Tidwell?
Because I actually already requested that she be sent back.
Oh, that's right. You said that.
I did speak with her this morning. She is also still not competent, and I wanted to flag this because Ms. Sellers reminded me that this is also one where the orders were done while they were CP cases. So I'm wondering if that's part of the issue with her case as well.
Did she actually go to Georgia Regional
She did.
and was restored, or?
So I emailed Miss Green yesterday because I thought maybe I was missing an order that said that, because they brought her back. She's now at ACDC.
Where she cannot get restoration because they don't have that there.
Yes.
Okay.
And I saw her there 2 weeks ago and realized she still needed some help. And so I don't know what the next step should be, what I need to present to the court or where we are on this one.
All right. What are your thoughts, Ms. Sellers?
I'm looking at my notes. And so I have in my notes that she was transported back in December of 2022 to DBHDD for an evaluation. And previously, in looking at the hearings for her, it seems like they couldn't even bring her before the court. So they sent her to DBHDD for an evaluation. That's what my notes say. And so it seems like there does need to be some type of order from the court. Well, the order from the court that finds her incompetent to stand trial, if that is the finding.
Sure. I just pulled up a picture of Ms. Tidwell. I'm remembering I interacted with her virtually. She is at ACDC, and it didn't go well. So I'm very comfortable signing an order based on my interactions with her. And I guess we just have to hope she gets back on track towards, it's remarkable that she had a bed at DBHDD and we lost it. But what were you going to say, Ms. Sellers?
So the order at this point would need to be for the order for incompetency to stand trial, and then the next 90 days that she received an evaluation and they report to the court once they have custody of her.
Okay, I've got that. I have a go by for that. So I'll take care of that on behalf of Ms. Tidwell. I may reach out to the two of you because I have a place in there where I indicate the last time a medical professional said Ms. Tidwell's not competent. And so you all may still have those evaluations. I'll just want to put that date in there, but I'll take care of the order, and then that puts her in the queue to get back to Georgia Regional. All right. Anything else, Ms. Sellers, as to Ms. Tidwell?
No, Your Honor, nothing further.
Okay. All right. Then should we bring Ms. Culpepper out, or do you need time to talk with her?
She can come out, Judge.
All right. And this is for a plea?
Yes.
All right. Mr. Peoples, is this your case?
It is, Your Honor.
Great.
Your Honor, that completes my business with the court. May I be excused?
Yes, ma'am. Thanks for your help today.
Thank you, Judge.
I have to check once I get down.
Okay, thank you.
Just to be a little delay, she has to use the restroom. So I'm gonna have to move those guys and put them in that temporary.
You'll put them back there?
Yeah.
Okay.
And
That's been the way our morning flows.
I'm happy to do Mr. Daniels, Judge. That one's gonna be non-negotiated.
Right. And so, we'll get it all on the record. Mr. Daniels' mother shared some things with me that I'll either get on the record, or it may be Mr. Peoples wants. Is your last name Daniels or different last name that Ms. Daniels shared? So we'll work through this. But no, let's take care of Ms. Culpepper. She can have a second, and then we'll go from there. Ms. Nelson, can you hear me?
Yes, Judge.
This afternoon, we will do our final plea calendar at 1:30. We can go for about a half hour, and then I have to get on that panel discussion about human trafficking. So we'll take a break, and then we'll resume whatever we didn't get to take care of after that.
Okay.
Thanks.
Stand by your count.
So this is the questions I'll ask you. If you have any questions about any of this, we'll step back and talk about it, okay? Okay. Oh, and this is all this. It's just this.
Ms. Rivers, are you ready?
Okay. All right, cool.
Yes, I am.
Great. Let's get Mr. Peoples on that screen there. This is position 15, State versus Yakira Culpepper, 23 SC 186653. Ms. Culpepper, how you doing?
I'm good. How about you?
I'm doing okay. Make sure you talk into the microphone. You're welcome to keep the mask on if you want to. You don't have to, but you're welcome to. But you need to speak into the microphone so Ms. Rivers can hear you. In a moment, Mr. Peoples, who you see on the screen there, he's the prosecutor. He's going to put you under oath. Once you're under oath, you'll need to answer all of his questions and mine truthfully and completely. It's real important that if you have any questions, because something's not clear or it's not going the way Ms. Wood thought it would go, that you tell her or me by waving your hand or something, say, wait a minute, time out, so that either I can explain it to you or Ms. Wood can explain it to you. Will you do that?
Yes, sir.
Okay, Mr. Peoples, when you're ready.
Thank you, Your Honor. Ms. Culpepper, are you able to hear me?
Yes, sir. Yes, I am.
Okay. Can you raise your right hand as best you can? Will you state your, do you solemnly swear the testimony you'll give in the proceedings before you this morning will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can lower your hand. Will you state your true, correct, and legal name?
Yakira Marilyn Culpepper.
Can you spell it for the record?
Yakira Marilyn Marilyn Culpepper Culpepper.
And Ms. Culpepper, before we go any further, I think you may be able to see it on the screen, but my guess is she'll yell at me if I don't tell you. Amber is on and has been on all morning saying she goes by Juicy. Where's Yakira? Where's Yakira? So she's there for you. Okay.
Thank you.
All right.
Thank you, Judge.
You bet.
Ms. Culpepper, are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, sir.
Is
Well,
there any
insulin.
Hold on. And any medication you take insulin?
Yes, I take insulin.
Okay, and does taking insulin make you dizzy or woozy or confused?
Sometimes.
Did
Make
you
me dizzy.
get it this morning?
I did not get it this morning.
Because you didn't get it, are you in any way foggy about what's going on?
No, sir.
Okay, are you at medical risk because you didn't get it this morning?
Not that I know of.
Okay.
I was supposed to get it this morning though, but nobody came.
Yeah, they've been having nurse issues over there. So let us know if you need to sit down at any point. But otherwise we'll keep going.
How old are you?
20,
And what is the highest level of education that you've completed?
high school diploma.
Okay, so then are you able to read, write, and fully understand the English language?
Yes, sir.
Thank you. Do you understand that you're charged with the following offenses? Count 1, aggravated assault. Count 2, theft by taking. Count 1, aggravated assault with a sentence range of 1 to 20 years. Count 2, theft by taking with a sentence range of 1 to 5 years. Count 3, possession of a firearm or knife during the commission of a felony, which carries a sentence of 5 years to run consecutively. And count 4, criminal trespass, which is a misdemeanor, which carries a sentence range of 1 day up to 12 months. Do you understand that?
Yes, sir.
You understand that you have the right to plead either guilty or not guilty to these charges?
Yes, sir.
Do you understand if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Do you feel like you had enough time to talk to me?
No, I need to talk to you.
You have a question?
Yes.
Oh, okay.
What's your question?
Okay, for that, like.
So he's
saying
just,
no guilty.
he read that off to make sure that you understand that's what you're actually being charged with. That's not what we're pleading to today.
Oh, okay, cool.
Okay.
And I was saying like, so if I plead not guilty, like I'm going to trial with it, right?
Right, so we're entering a plea, so there will not be a trial.
Okay.
Okay.
So I want to pause here. Do you have any questions for me or for Mr. Peoples, or did Ms. Wood clear up what your question was?
I think she cleared it up for me.
Okay, why don't you ask your question again, Mr. Peoples, because I don't think she answered it about the defenses, et cetera.
Okay. Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Okay. Do you need any more time to speak with your attorney?
No, sir.
Okay. Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
So waived.
Ms. Culpepper, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a sentence of, Your Honor, the state is asking that count 1 be reduced to disorderly conduct. Counts 2 and 3 be null prost, and so she would only be pleading to count 1 of reduction to disorderly conduct and count 4 criminal trespass, with 12 months of probation, the first 180 days to serve, with to receive credit for any time that she's already served, and completion of an anger management course, as well as a stay away from the victim to be named shortly.
Got it.
Do you understand that, Ms. Culpepper?
Yes, sir.
Do you understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each of those charges, as I just explained to you earlier, and run those sentences consecutively or one after the other?
Yes, sir.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have a right to withdraw your plea of guilty?
Yes, sir.
Do you understand that this plea could be used to enhance any sentencing on other convictions in other jurisdictions, as well as in this jurisdiction, including in the federal courts?
Yes, sir.
Do you understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Are you a citizen of the United States?
Yes, sir, I am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering your plea of guilty today?
Yes.
There are certain rights that you give up by entering a plea of guilty, and those include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand all those?
Yes, sir.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Is it a decision to waive these rights and enter a guilty plea because you are in fact guilty?
So you're pleading guilty to the misdemeanor, so he's asking if you are in fact guilty of disorderly conduct and criminal trespass, and would say yes.
Yes, sir.
How do you plead to count 1, disorderly conduct,
Guilty.
and count 4, criminal trespass?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that unless counsel is substituted or permitted to withdraw, that defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, sir.
Do you understand that you have only 12 months from today for a misdemeanor charge and 4 years for felony to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes, sir.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself?
Yes, sir.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on December 24th of 2022, law enforcement responded to a dispute call at 1088 Kipling, Kipling Street, Southeast in Fulton County. Upon arrival, they spoke with the caller, who was identified as Miss Shakevius Kimber, Shakeeivious, Kimber, Kimber, who stated that Ms. Kimber stated that on that day, she heard her daughter, Miss Ketoria Knight, Ketorria, Knight, Knight, in a verbal dispute with her romantic partner, Ms. Culpepper. Ms. Kimber stated that it was at this time that herself and Ms. Culpepper got into a dispute that escalated. She stated that Ms. Culpepper struck her in the head, leaving no visible bleeding or bruising that law enforcement could see. Ms. Kimber continued informing law enforcement that she showed the residents the screen door that Ms. Culpepper had shattered as she left. And she stated that Ms. Culpepper had pointed a firearm at her. Counsel, do you stipulate there's a factual basis for this plea?
We do.
Your Honor, the looking a little bit deeper into this, it's at issue. We believe that if this was to proceed to trial, it's at issue if that the firearm was pointed at her, or that the firearm was actually taken, would be something that the state would actually be able to prove. And therefore, we believe that this is an equitable resolution to this case.
Okay. All right, I'll ask Ms. Culpepper a little bit about that when I get there. But thank you for all that.
Thank you,
Ms. Jackson. What type of criminal history information do you have for Ms. Culpepper?
One prior arrest. It was on June the 27th, 2021 in Clayton County for simple battery and cruelty to children in the 3rd degree. Defendant does have an open case pending in Clayton County for simple battery, family violence, and cruelty to children in the 3rd degree. Nothing in addition, Your Honor.
Okay, thank you. Ms. Wood, do you know the status of the Clayton case? Is that relates to that arrest from 21?
It's the same one, Judge. She actually missed her court date there because she was incarcerated here. So she does have a Clayton County hold.
Okay. And who is the alleged victim in the Clayton case?
Her father.
Her father.
And I've talked to him, Judge, and that.
The Clayton case will resolve itself
Yes.
when Ms. Culpepper goes there.
Yes.
Okay. But it's not Ms. Knight, or it's not some kind of permutation of this situation.
No, Judge.
Okay. All right. Ms. Culpepper, a couple questions. So Ms. Knight was your girlfriend?
Yes.
Was.
Yes.
Not anymore.
Haven't talked to her.
You don't talk to her. And Ms. Kimber is Ms. Knight's mom.
Yes, sir.
Okay. You're 20. Ms. Knight is about your age?
She's 21. Yes, sir. 22 now.
She's what?
22 now.
Okay. Ms. Kimber obviously is older.
Yes, sir.
Okay. And the story is that you and Ms. Knight were having words. That's the story. I want to understand that you and Ms. Knight were having words, and then somehow Ms. Kimber got involved.
Yes, sir.
Okay. So what you're pleading to is simply disorderly conduct, that there was some kind of fussing going on Kipling Street, and then some door got damaged. You're not pleading to anything about a gun. I want to make sure I understood what was going on. Did you and Ms. Knight continue to have a relationship after this date, this Christmas Eve?
Yes, sir.
Okay, so you going in different directions wasn't a direct result of this.
Yes, sir.
It was a direct result?
Was
It was not. Okay, got it. Mr. Peoples, is the stay away / no contact just in connection with Ms. Kimber or also Ms. Knight?
Both, Your Honor.
Okay. Are you comfortable? In some ways, you don't need to be comfortable, but I want to make sure I'm not setting you up for a difficult condition of your probation. If you need to stay away from no texting, no social media, not rolling by their house, both Ms. Knight and Ms. Kimber, are you up for that?
Yes, I am.
Okay.
Yeah, they got my stuff.
I'm sorry.
They got my stuff.
If it can be arranged that you can return one time with law enforcement.
Okay, cool.
You need to get some stuff.
Yes.
From Ms. Knight or Ms. Kimber?
Ms. Knight.
Okay, that's the simpler one. You'll still need to talk with your lawyer about it, but as long as there's an officer there, you get your stuff, you go. It sounds like the bigger issue was Ms. Kimber, and your stuff is not with Ms. Kimber. Okay, all right. Do you have any questions about anything we discussed?
No, sir. Well, actually, yes, I do. So with that, am I just leaving or?
You'll have to go to Clayton first. So they'll get you from Clayton and go take care of that, and then you'll start your probation.
Okay.
Okay, do you have anything you want to add?
Briefly, Judge, she's been in custody since January 31st of this year, so she's already done the 180 days, 80 days. She's already done 190 to be exact. She's 20 years old. She is a high school graduate. She was attending Clayton State. I hope that she can get back on track there. She was working at Checkers before her arrest. She has no previous history other than the Clayton County matter. And she wanted the court to know that she's been in the New Beginnings program, and they all wrote letters in support of her if the court was interested. I did speak with her family. As you know, her family friend, Amber, is on the call. Her father believes that both of these incidents in Clayton and here are a symptom of misplaced grief. She lost her mother. And so we're hopeful that the anger management class will be beneficial to Ms. Culpepper moving forward, Judge. We just ask that you accept the state's recommendation.
Got it. Okay. Ms. Culpepper, any other things you want to talk about before I decide to accept your plea and impose sentence?
No, sir.
Okay. Well, I find there's a factual basis for your plea to disorderly conduct and criminal trespass. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. You're doing it because you've decided it's in your best interest. And a knowing plea just means you've understood all the many things you've already told Mr. Peoples you understood about the rights that you're giving up. Do you agree that your plea is knowing and voluntary?
Yes, sir.
Okay, I'll accept it then. And I'm going to sentence you as follows. For count 1, which has been reduced to disorderly conduct, I'm sentencing you to 6 months to serve. You'll get credit for all the time you served, and you've served 6 months. So you're done with that. Count 2 is dismissed, 3 is dismissed. Count 4, I'm sentencing you to 12 months probation. Special condition of probation number 1 is that you complete an anger management course. Special condition number 2 is no contact, direct or indirect, with either Ms. Knight. And what was Ms. Knight's first name? Katoria. All right, that's already been spelled on the record. And same with Ms. Kimber, her mother, no contact with either of them. And no firearms while you're on probation. So if you've got a gun in your house, it needs to get out of your house. If you've got a gun in your car, it needs to get out of your car. While you're on probation for those 12 months, no firearms. If after 6 months of your probation, you've completed the anger management course and there've been no violations of probation, then I'd be willing to terminate the probation. You just need to reach out to Ms. Wood, and if she gets a good report from probation saying there've been no issues and here's proof of anger management completion, then I'll close out your case. Mr. Peoples, anything else on behalf of the state?
No, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
All right, Ms. Culpepper, you're going to get some information from Ms. Wood about how to report to misdemeanor probation. Obviously, you can't do that till you get out, and you're not going to get out till you go to Clayton and clear up that situation. But then you'll be released, and you're going to go live wherever you live, not with Ms. Knight, not with Ms. Kimber. And then you need to report to misdemeanor probation. If you don't, they're going to take out a warrant, and there goes getting done with only 6 months. So Ms. Wood's going to tell you where you need to go, or a phone number to call, or something to get signed up with misdemeanor probation. Make sure you do that once you get out.
Yes, sir.
Any questions?
No, sir.
All right. Good luck, everyone.
Thank you.
Thank you, Judge.
Thank you, Your Honor.
So, hey, just so you know, Ms. Culpepper, Amber says you don't need your stuff that is with Ms. Knight. Amber's going to get you new stuff, she says. You got to hold her to that. It's in print. All right. I think all that's left for this morning is to handle Mr. Daniels's 3 cases. Is he here? Okay. Well, the case management's not till 12:30. So if we can fit it in, great. Otherwise, we'll bump it to the afternoon. If that's just simpler for everyone, we can do that. We have that one hiccup that at 2, I have to go be on this panel for a while. So we'll see. But Ms. Willingham is gone, so I assume it'll be the afternoon.
I'm also available to take the plea for Mr. Vaughn if needed, Your Honor.
Okay. Well, we'll huddle up. Let's see how long Mr. Daniels takes.
Okay.
I reserve the right to revise what we do.
Understood.
Oh, look at the dress down look. Uh-huh.
Thank you, Sergeant.
All right, get back out there on those barricades. He's got his own personal stash back in Chambers. He carried it all the way up here, man. I'm good, he says. Mr. Daniels. Yep. So all three of Mr. Daniels's cases are deferred drug court.
I was about to ask you, so this is technically an arraignment court date for these cases, is that correct?
Correct.
Okay.
I mean, he may well have been, I know at least one of his cases was with Judge Dunaway. I don't know how they managed arraignments, but they're all deferrals, as in it was, if you successfully complete drug court, the state will dismiss the indicted charges. Because I just looked at one of his orders transferring him to drug court, and that's why it's here rather than a probation matter.
Got it, okay.
All right, Mr. Peoples, are you ready?
Yes, Your Honor.
Okay, great. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
Great. We've got Mr. Daniels out here. Hello, sir.
Hey, how you doing, Your Honor?
Good to see you.
Good to see you also.
Mr. Daniels, you have 3 cases on the calendar, positions 12 through 14, and it's my understanding that you're prepared to enter a non-negotiated, meaning the prosecutor is going to recommend one thing and Ms. Wood is going to recommend something else, non-negotiated plea in the 3 cases. Is that correct?
Yes, sir.
Okay. Even though these are old cases, we are early enough in the process that if you don't like the sentence that I impose, if the sentence I impose is more severe than what Ms. Wood asks for, so I'm going to just make it up. Let's say she asked for 2 years probation and Mr. Peoples says 5 years probation, and I give you 5 years probation. That's a more severe sentence than what Ms. Wood asked for. You have the right to withdraw your plea today. If it's different in a bad way from what Ms. Wood recommends. You don't have to withdraw, but you can. You go back to jail and we'll just move your case toward trial. But I want you to know you're not locked in if I give you a sentence that's more severe. Now, in the future, you will be locked in if you enter a guilty plea and you don't like what it is. And certainly if you go to trial and you're found guilty, you don't get to withdraw anything if a jury finds that you're guilty. But that's a ways down the road. But having shared that, what we're going to do now is have Mr. Peoples, who's on the screen there, put you under oath. Once you're under oath, he's going to ask you a bunch of questions. You need to answer those questions truthfully. And then, assuming I accept your guilty plea in the 3 cases, we'll talk about sentencing. If you at any point need to talk privately with Ms. Wood, let me know. And if at any point you've got a question that you want to share, just let me know, because we need to pause so I can or Ms. Wood can try to answer your question. When you're ready, Mr. Peoples.
Thank you, Your Honor. Mr. Daniels, are you able to hear me?
Yes, sir.
Okay. Will you raise your right hand as best you can? You solemnly swear that the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can lower your hand. We state your true, correct, and legal name for the record.
Robert Anton Andrew Daniels.
Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you?
38.
And what is the highest level of education that you've completed?
I have a GED. I'm in some college.
Okay. So then are you able to read, write, and fully understand the English language?
Yes, sir.
You understand that you're charged with the following offenses in 16 SC 143134. Count 1, possession of a controlled substance with a sentence range of 1 to 3 years, and count 2, possession of marijuana less than an ounce, which is a misdemeanor, which carries a sentence range of 1 day up to 12 months. In 19 SC 167410, count 1, possession of heroin, which carries a sentence range of 1 to 3 years, and count 2, crossing the guard lines of the jail with prohibited items, which carries a sentence range of 1 to 4 years. And 19 SC 169174, count 1, theft by shoplifting, which carries a sentence range of 1 to 5 years. Count 2, giving false name, address, or birthday to law enforcement, which was a misdemeanor, which carries a sentence range of 1 day up to 12 months. And count 3, possession and use of drug-related objects, which is also a misdemeanor, which carries a sentence range of 1 day up to 12 months. Do you understand all of that?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, sir.
Do you understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial on these charges?
Yes, sir.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes, sir.
Do you need more time to discuss these cases with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Counsel, do you waive formal reading of the indictments?
So waived.
Do you waive any and all defects in these indictments, including any with respect to your client's name?
We do.
Your Honor, this is a non-negotiated plea, and the state is asking for that we'd be asking for 8 years to serve 3, with 8 years with a cap of 3 years to serve. We would be asking that he complete the RSAT program. And I've spoken extensively yesterday with Mrs. Daniels, his mother, and I believe that the RSAT program is something that is going to be extremely helpful for Mr. Daniels. But that's what we would be asking, Your Honor. I would not ask for any alcohol or drug evaluation and treatment because if the court does sentence to RSAT, I believe that that should cover everything that's needed. My understanding of the program is that it's extremely intensive and that should cover a full breadth and depth of any substance abuse issues. Do you understand that, Mr. Daniels?
Yes.
Do you understand, however, the court does not have to accept this recommendation and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, I understand. Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess nor use a firearm while on probation?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, sir.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand all these rights?
Yes, sir.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
No, sir. Yes, sir.
I'll ask it one more time. Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
In indictment ending in 134, how do you plead to the charge of possession of a controlled substance?
Guilty.
And count 2, possession of marijuana less than an ounce?
Guilty.
In indictment ending in 410, how do you plead to possession of heroin?
Guilty.
And count 2, crossing the guard line with prohibited items?
Guilty.
In indictment ending in 174, how do you plead to count 1, theft by shoplifting?
Guilty.
Giving false name or address to law enforcement?
Guilty.
And count 3, possession or use of drug-related objects?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, sir.
Do you understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
Do you understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes, sir.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself?
Yes, sir.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that.
Which case are we talking about?
Your Honor. One moment.
While he's looking for that, Ms. Wood, I didn't jot down for the 16 SC case. What is your understanding of what the range is for count 1, which is possession of certain controlled substances?
Judge, so this one, I don't have a file for this one based on the age and it being a deferral, so
Okay.
I'm not sure what the alleged amount was.
Okay, well, I'll look up the indictment.
Oh, let's see. It's an accusation. Okay, it's alprazolam, Schedule 4, Judge.
And that's the first report.
All right, are you ready? Or okay, which case do you want to start with?
16 SC, the 16 SC case, Your Honor.
Okay.
The factual basis will be that if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on February 6th of 2016, while on patrol, the South Bus Loop at the College Park MARTA station, law enforcement stopped by the Route 83 to ensure that Mr. Daniels, the individual identified as Mr. Robert Daniels, had rendered his bus fare. The officer stood by watching Mr. Daniels search through his satchel, and he asked Mr. Daniels if he needed any help looking for any additional funds in his bag. Mr. Daniels stated, quote, "Yes, help me look." While conducting that search, law enforcement noticed a prescription pill in the bag by the name in the name of Angela Daniels, and asked him if that was his prescription since it clearly had a female's name on the label. He noticed that the prescription pill bottle contained 2 clear plastic baggies containing a green leafy substance, which was suspected to be marijuana. They asked Mr. Daniels what's in the bottle. He stated, "It holds my weed." Mr. Daniels was then arrested and transported to the precinct. A search incident to arrest discovered 4 individually sealed plastic baggies containing white in color pills and blue in color pills, which were suspected to be alprazolam. Counsel, do you stipulate there's a factual basis for this?
We do.
And Your Honor, in the next will be 19 SC 167410. One moment, Your Honor, I apologize. I had the report sent over to me. Your Honor, I'll move on to 19 SC 169174. On March 10th of 2019 at 970 Mansell Road in Roswell in Fulton County. The individual identified as Mr. Robert Daniels had been detained pending a show up. The officer asked for his name. He provided the name of Andrew Jones with a birth date of May 7th, 1987. And after he was placed under arrest, he provided the proper name of Robert Andrew Daniels with a birth date of May 7th, 1987. Counsel, do you stipulate as a factual basis for this?
We do.
And lastly, in the indictment ending in 410, on November 28th of 2017 at 901 Rice Street, Atlanta, Georgia. Mr. Daniels was brought to intake at the Fulton County Jail on a probation warrant. And during a routine strip search, it was revealed that he had a baggie containing in his anal cavity, containing what was suspected to be heroin. Counsel, do you stipulate there's a factual basis for this plea?
We do.
Thank you. That's all from the state, Your Honor.
Thank you, Mr. Peoples. Ms. Jackson, what does your criminal history information show for Mr. Daniels?
It's 30 cycles. The defendant's last arrest was June the 3rd, 2020 in Fulton County for a failure to appear. The defendant does have misdemeanor convictions. It's one in 2017. Received a no low contendory sentence for theft by shoplifting. It's another one in 2017 out of DeKalb County for giving false information to an officer. It's another one in 2017 for possession of marijuana less than an ounce. And the defendant received a no low contendory sentence in 2013 for possession of marijuana less than an ounce. And I apologize, it's a little bit out of order, Your Honor. There was one in 2018 out of Chamblee, Georgia for theft by shoplifting. And there was one in 2011 out of Maryland for assault. There was one in 2008 out of Cobb County for simple battery. It does appear to have a history of failure to appear. It's one in 2020 and two in 2019. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, it doesn't sound like Mr. Daniels has any felonies. Do you have any probation history for him? And good morning.
Good morning. It looks like he is not on probation, and the cases that ended for probation and for him was 14 SC 124679, ended in February 7th, 2018.
So he does have a felony conviction. What was that for, the 14 SC?
It looks like it was first offender for possession with intent to distribute and shoplifting. And then there was a 14 SC 125278. So there was two.
Okay.
And both pleas were taken at the same time, looks like.
Got it. They were consolidated for purposes of sentencing. Okay. That's very helpful. Ms. Wood.
I'm sorry, what was the year on that felony conviction? 2014?
They were 2014 indictments. I don't know when the plea was.
Thank you. Judge, I believe that you may be a little familiar with Mr. Daniels.
We go way back.
His situation, he is 38 years old. He was born in Detroit. He grew up here.
He has a lot of family support here. I've spoken to his mother and his daughter. And I understand that the state has also spoken with his mom and understands her desires for his case. He has 3 children, ages 22, 15, and 12. He does have his GED. He has some college. He studied sound engineering, and he was working at QuickBox prior to this most recent incarceration. Judge, it's my understanding that he does suffer from anxiety and depression, and that has been what he's been trying to self-medicate with the various drugs that he struggled with over the years. It looks like he's been in throughout. So if we're totaling up from the first case, I believe he's done roughly 575 days, but that's over the course of many various jailings, but he did want to put that on the record.
Okay.
We're asking the court to consider 6 years probation, serve 18 months with credit for time that he has been in. We understand that that is different from what his mother's request is to the state and what the state's request is, and that's what he wants the court to know that his desires are.
Okay. And maybe this is a question for Mr. Daniels. Your recommendation, if Mr. Daniels were to receive credit for all those different chunks of time, would basically release him to what type of care?
Mr. Daniels has informed me, Judge, that he believes that he would be able to enroll in a program.
He'd find something.
In outpatient care, Judge.
Okay. Thank you for sharing that. Mr. Daniels, well, let me ask you, Ms. Wood, you said you have also spoken to his daughter. Would that be the 22-year-old or the 15-year-old or the 12-year-old who was giving you her perspective on Mr. Daniels?
The 22-year-old, Judge.
Okay, got it. Mr. Daniels, are your 3 kids in the Atlanta area or elsewhere?
Yes, they're in Coweta.
Okay.
And
so one's an adult, so she's wherever she wants to be. Are the 15-year-old and the 12-year-old together?
Yes.
With their mother?
Yes.
Okay.
In Coweta.
Are all 3 kids with the same woman, or it's 2
Yeah.
different moms?
Same woman.
Okay, got it. I'm trying to remember when we worked together when you were in drug court. You were working as a sound engineer, I think, and also going to school. Is that correct?
Yes, Your Honor.
And for a while, you were in sort of a parallel program to drug court. I know you went to St. Jude's for a while, but there was, it started with Z or something, someone house. Where did you?
Zabin.
Zabin, okay. Got it. What do you want to add, if there's anything you want to add to what you've heard Mr. Peoples talk about and Ms. Wood, et cetera?
Just that I would really like you to accept Ms. Wood's proposal. I want to use my first offenders. You know what I'm
So
saying?
you've used first offender?
No, I would like, all right, so on the cases that were brought up with the felony charges, I used my drug first offenders and I completed that. So they told me that, my attorney then explained to me that if by using the drug first offenders and completing that, I could use my first offenders so that I don't have any felony convictions on my record.
Got it.
I believe I could complete it successfully. If given the opportunity, a lot's changed for me.
Tell me what's changed.
For one, getting a lot more control over my addiction and my lifestyle that I had back then. As you can see, my criminal history, but for the last almost 5 years, I haven't really gotten in any trouble, you know what I'm saying? Compared to my criminal history, I think that actually says a lot. I know it's not a lot to a lot of people, but
it's important.
Yeah, you know, like I've really changed a lot of my addiction, my life. I mean, I know that me and my mom don't see eye to eye on everything. I don't think I should be punished for my addiction, especially when I'm seeking help. I'm willing to seek help, like as part of probation. My first offenders, I'm willing to be a stipulation. I'm, you know, saying go to the methadone clinic, whatever. You know what I'm saying? Like, I want to change my life. I don't want to, you know what I'm saying? Like, my track record is bad, but over the past few years, I've been improving a lot. Like, ever since, like, I ain't even been arrested since drug court. And, you know, started going back to college and everything in life. I mean, like, I think that the prosecutor's recommendation would set back a lot of progress, and that I'm trying to move forward in life right now. You know what I'm saying? I have the ball rolling, and I would like to keep it rolling. I mean, I know that I have to deal with these cases, so.
You do. Tell me what you mean when you say you have the ball rolling.
I'm heading down the right path now.
Right. But like tell me what's different from when you and I worked together, where you said very similar things and things seemed promising. You were a student and you were working, may have been Soundbox back then. I know you were working, you had, at least as you described it, a lot of good things going for you. And then things would keep blowing up. You test positive, you leave a program, this or that. And so I'm trying to feel confident that somehow it's different now because, and then I'll hear you out, you described the prosecutor's recommendation as something that is going to set you back or meant to set you back. It's certainly not meant to, because the prosecutor's recommendation is, let's get Mr. Daniels treatment that he cannot walk away from. I don't know that that's a bad idea, but I do want to hear from you as to why you think having to get treatment, as in you can't walk away from it, is a bad idea, as opposed to you saying, don't worry, Judge, trust me, the fourth time, I mean it when I say I'm going to stick with a program.
I mean, all I can really do is show you. I mean, I could tell you my intentions. You know what I'm
Tell me
saying?
your intentions.
My intentions are, you know what I'm saying, if I was to be able to do this and we'll keep the ball rolling as we have been saying, would be, you know what I'm saying, to continue to continue on my path to success, you know what I'm saying, staying sober, you know what I'm saying, going to classes, you know what I'm saying, NA classes, spending time with my kids, you know what I'm saying. I don't want to be away from my children for that long is another thing, you know what I'm saying?
That would be a problem. The benefit would be when you were with your children again, you would be a sober dad. And you haven't always been a sober dad over the last 12 years for your youngest. And I don't know when you were first struggling with the addiction, and if it's related to the way you're self-treating some mental health issues. It may go further back, but than just 12 years. But I'm sympathetic to wanting to be with kids, but I'm also sympathetic to the kids needing to have a parental figure who is constant, rather than I'm here for a little while because I'm clean, and then I'm gone for 6 months because I relapsed or I'm doing this, and then I'm back for you, and then I'm gone. That up and down is not healthy.
I don't do that, Your Honor.
Well, I know you do, because it happened when you were in drug court, is that you disappear for a while and you get locked up. And I'm not saying it in a bad way, not that you're off hurting other people. I don't see anything in here, maybe something in Maryland, but a lot of the criminal history we see here is you doing your best to take care of yourself, but doing it in ways where you're having to do some stealing and you're certainly using. And that doesn't keep you healthy and centered and present in a meaningful way in your kid's life, your mother's life, or anyone else's life. So, but I also hear what you're saying, is that this notion of I'll be away for a while. I don't want to be away for a while. What was the last job you had?
QuickBooks. I was working there right before the day, you know what I'm saying, that the day they came to my house for the warrant, it was the only day I had off that week. I literally worked the day before, so.
Okay. All right. Anything else you want to add?
I've said everything I have to say, Your Honor.
Okay. Mr. Peoples, you mentioned, and I neglected to write down the range for count 1 of the 16 SC case.
It was 1 to 3, Your Honor.
Okay. So the only way you get to either 6 years probation or 8 serve 3 is that we'll have to stack some of these.
That's correct. Your Honor.
Do you have a perspective, Mr. Peoples, on whether Mr. Daniels should be sentenced as a first offender under the first offender statute? I have looked up his 214 SC convictions, and for those, he did indeed use the drug first offender statute.
I would defer to the court on that, Your Honor, because from what you're saying, I think there may be a difference here, and I'm not too sure about it, so I would defer to the court.
Okay. All right. Mr. Daniels, first, I find there's a factual basis for each of your three cases. And I'm going to echo something I already said. I get it that none of these is a particularly serious case. You're not holding the gun to someone's head and taking their stuff, because we wouldn't be talking about probation if it was something like that. These cases are all part of what I see as a pattern from 2014, 2013, is your first NOLO, onward, where you're struggling with addiction and maybe some mental health issues as well. And the way you're treating it, if you are treating it, is through taking things that aren't necessarily prescribed to you to take. So I see someone who needs help. I don't see someone that we ought to be worried about and isn't safe in the community, et cetera. Although if you're shoplifting, I'm sure there are places that would wish you don't go back in there. But I do find there's a factual basis. I also find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to enter these pleas. And you can withdraw your pleas if you are unhappy with your sentence, if it is more than 6 years probation. But I also find that your pleas are knowing, meaning you've understood all the things we talked about. Do you agree with that?
Yes, Your Honor.
Okay, then I'm going to accept your pleas. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, which you will be, if you have a minor violation, you and probation work through that. You don't have to come back and see me. But if it's a serious violation, which would be a new arrest or something like that, or if you test positive too many times, that comes back to me, and we'll work through the consequences of that kind of violation. Ideally, there are no violations at all, but if they are, that's how they'd work. So how to structure this? I do think, just so you know up front, that you ought to do the RSAT program. I think that you need to go start to finish in a drug treatment program and not leave it because the addiction beats you. That happened at least 3 times when we were working together, because we had to come find you and get you into St. Jude's, and you left St. Jude's there with the Zabin. We didn't give up on you, and we didn't just give you the light touch in drug court. But there's a limit to drug court because none of the doors are locked. You can always walk away from drug court, and that's ultimately what you did. But what I'd say is actually your addiction pulled you away from drug court. I don't think you wanted to leave it. I don't think drug court was bad to you. But you had enough stuff going on up here in your head and with the drugs that it wasn't enough. Drug court and St. Jude's, in other words, voluntary inpatient treatment weren't enough. And my concern for you is that if we don't give you the tools you need to wrap your arms around this at age 38, I don't know that we'll have at age 40, because the reality of what's out on the street these days is you may think you're getting something kind of low key and someone's dropped some fentanyl in it, and then we find Mr. Daniels unresponsive in a parking lot someplace. And that is the worst thing that could happen to your kids. You want to be there for your kids. Your addiction takes you away from them forever. Hey, where's your dad? Answer is he's dead. He killed himself, and not intentionally, but that is too much of a risk where we are right now. And I don't say that as some judge who's not connected with what life is like for folks. I've been doing drug court now for 7 years, working with clients. And I know when we've got a client who is wrestling with something that is stronger than what drug court can handle. And that's you. And that's someone I'm going to see tomorrow. I've got my list of folks tomorrow who are going to be terminated because we've tried working with them, give them a second chance, give them a third chance. They cut their ankle monitor and they relapse into what's going on. You have a lot of hope going for you because you are someone who was able to work and deal with the addiction at the same time. But that means you're a functional addict as opposed to the ones who live out of a dumpster. You had a place to live, you were working, but you hadn't beat the addiction. And I think if you're honest with yourself, you'd say, you're right. So when you say, I want to get back to these things that are propelling me forward, they were propelling you forward back when I worked with you. You had a good gig and you were going to school and you were using. And then look what happened in the end. The using won out over what was going on then. And you kind of put things back in order again. And you know better than I do how many times you've repeated that larger cycle of, I got my stuff together, things are okay. And then the wheels fall off and then they aren't okay again. And then you say, wait, no, now they're good again. You're not 21, you're almost 40. You've done this a few times. We make sure that there isn't another time because I don't mean to suggest you've led a lucky life, but you've lucked out in the sense that each time you've come out okay, when there's been a crash and a burn and a serious relapse, you come back alive. Maybe that's because you've got family around you, but there's no guarantee that you come back alive the next time things go real bad. I don't usually give that much of a sermon, but I want you to understand why I think RSAT is the right thing. It's not because, I got to punish Mr. Daniels. This is not about punishment at all. It's about getting you into a program that you can't quit because you've quit all these other programs. And I don't have confidence that you'd get on probation. Like, don't worry, I got this one. I'm going to go to some classes and I'm going to stay clean. I believe you want to do that. I don't think you can do that. And that may seem like I'm not being supportive. I'm being real and I'm being worried. And that's why I'm doing this. I don't need to break out how the sentence will work if you know you're going to say no, thank you. Because you right now you have the ability to say, I'm not going to do a sentence where I have to go do RSAT. That's how early we are in the process. The sentence will be sort of like what Mr. Peoples described, but it's only long enough so that you can complete RSAT. And I think you know this, but if you don't, it's important to know the point of RSAT, if you get sentenced this way, is you actually get released and put into aftercare as soon as you complete RSAT. So if I structure your sentence along the lines of 3 years to serve followed by 5 years probation, you actually don't serve 3 years. First of all, you get credit for some of the time you've been in, but you go do RSAT. And when you finish RSAT, it's sort of like going to halfway house. They release you to get the aftercare, which is more like drug court, but it's making sure that the RSAT is sticking. And you're back in the community. So you'd be able to visit your kids, you'd be able to work. And you're technically on parole rather than probation, but you get probation credit for that. And it's just the tail end of the RSAT program. So you wouldn't do all 3 years, but it takes a little while to get in the program. And the program, sort of like drug court, it's in months, it's not weeks. So that's how I would structure your sentence, but with RSAT as the centerpiece. And then you're on probation for a while, so we make sure that everything sticks and that you're getting some supervision. That's what I intend to do. If you know you're going to say no thank you to that, you should tell me no thank you right now.
No, thank you, Your Honor.
Okay. Well, we're going to let you go back. I'm going to, Mr. Daniels, just so we're super safe here in terms of process, he's waiving arraignment. So you will file waiver of arraignments in his 3 cases. Mr. Peoples will get you discovery. And then Mr. Daniels, what'll happen next is Ms. Wood is going to meet with you, show you the discovery in these cases. The state gets to pick which one it wants to try first. They're going to pick the one that is best for them. And we'll have a trial. And of course, if you are found guilty at trial, there's no thank you. I'm going to sentence you. I'm going to sentence you to RSAT. So you can kick the can down the road. But if you're found, you may not get found guilty. I want to make clear at one of these cases, it wasn't really clear to me how the state was connecting you to everything, but for the purposes of the plea, we were working through that. If you're found not guilty in not 1 or 2, but all 3 cases, when that's over and done with, you're out and you're doing what you want to do. Until then, you're in. And if you are found guilty in one of these cases, I'm going to send you to RSAT. So just know what your array of options is. And then keep talking with Ms. Wood. If we need to get you in here again for a plea, we can do that. Otherwise, I'm going to push these lawyers to get ready for trial because these are older cases. They're harder for the state to put together because witnesses have gone this way and that way. And we'll go from there. Do you have any questions about any of that?
No, Your Honor.
Okay. Well, I appreciate your time on this, Ms. Wood and Mr. Peoples. We'll look for those waiver of arraignments and we'll move these forward.
Thank you,
Okay.
Judge.
All right. All right, here is where we are time-wise. It's 12:18. We're going to break for lunch. If folks could be back at 1:30, we will pick up with Mr. Vaughn and our afternoon calendar At 2, we have to take a break for about half hour, 45 minutes, because I'm on some human trafficking panel with someone from your office from before, Camille. She's got a very different last name now.
Start with the Z.
Yeah. And then we'll do the rest of it. So Ms. Jackson and Ms. Tucson, we'll see you back at 1:30. Thank you for your time this morning. I know we have at least one plea this afternoon, if not more. And we'll pick up then. And it'll be on this Zoom. I'm going to leave this Zoom up and running.
Your Honor, I'm sorry for
Thank you, Your Honor.
interrupting. Is that another calendar?
It
1:30?
is. There's a 1:30 calendar. It's a final plea calendar. We'll get Ms. Nelson to shoot you a copy if you don't have it.
Okay, I'm not sure who's covering that. I don't think I'm scheduled for it. I just want to make sure. Thank you.
Okay. Yeah, it was a separate calendar.
Thank you.
Okay. Thank you.
Thank you, Your Honor.
You bet.
He's still using up to the time.
Okay.
He's been doing this for over 20 years.
Well, I hope to get him help. We'll see what happens.
Thank you so much.
All right. I will mute.
Deputy Abate. When you get a chance, can you give me a call?
a lot.
Okay, we are back on and the microphone is working. So we are going to try to knock out a couple things before we have to take a break this afternoon, then we'll do the rest. I need to know who represents Mr. Fields.
Great afternoon, Your Honor. Attorney Benchita for Mr. Fields.
Hey, Mr. Benchita, how are you doing?
Doing well, no complaints. How about yourself, Judge?
I'm doing okay. Were you going to be resolving Mr. Fields's cases today, or were we moving them to the trial calendar?
So I spoke to Edie House, Your Honor, and what we were going to ask the court is if we can move it to another final plea date. And why that is I know the discovery was at least 2 terabytes. So it took the state about 2 weeks to put it on. So there's still a lot of stuff to go through. When I spoke to the state, we have a possible global resolution that we're working on. So I just need to sit with my client and go through all that. But I also was told that there's another case that was he was just charged with that I may be appointed. I think it's a kidnapping and another assault or something. So that one I may be appointed to as well. So
okay.
we're trying to do a global matter.
Let me ask a couple questions about that. So were you retained by Mr. Fields for any of these, or you were appointed?
I was appointed to about 6 or 7 of his matters.
Okay, you say 6 or 7, those numbers alarm me. Are some of them unindicted cases, or you represent him in other jurisdictions?
No, they're all in Fulton County. So some of them were unindicted, some I believe are with different courts. But to my knowledge, it was, I want to say 7. And then I was just told today about this new matter.
Okay. Next question is for you, Mr. Hiles, and good afternoon and nice clothes closet. So is this new indictment an indictment you brought and is gang related, or it's just one of the CP cases that is catching up with Mr. Fields?
Your Honor, it's a CP case that happened, I believe, on June 30th of this year. The offer
is it kidnapping within jail? Because Mr. Fields has been in jail for almost 2 years now.
Right. Yes, I think it's alleged that maybe that's why I'm trying to see if we're even going to pursue it. I think based off my first glance at it, it looked like, slight movement can get you a kidnapping charge.
Sure can.
And so I know that's the law, but I need to see a little bit more, at least get a video. But the offer I've extended to Mr. Benchita is for all of it. It would include all of his other cases that are indicted and or unindicted, except this last one that just popped up end of June, beginning of July. I just need to look into it a little bit more to see if I'd even pursue it.
Okay, I'm looking for when you say new, but not in. I'm looking at Mr. Fields now in Odyssey, and I don't see it indicted. There's a battery and kidnapping that Ms. Bumpus is listed as his attorney, but that's a CP. There's a riot, and Mr. Benchita is listed as counsel, but that's a CP case. The only indicted ones, I think, are the 2 that we've got on our calendar. Is that correct?
That's correct. And if he accepts the cases, then I would just enter a
NPPJ or whatever for the CP cases.
That's correct.
Okay. All right. But it's new on Mr. Benchita's radar. As of right now, Mr. Benchita, it says that Ms. Bumpus has that kidnapping case, the one from June of this year. I think it makes sense for you to wrap your arms around everything. But if there's a global resolution, I'm sure we can sort that out. But let me do this. I understand there's a lot of discovery. I'm reluctant to put it down for another final plea. I'm more interested in preserving Mr. Fields' final plea rights, but moving it to a trial calendar so people are focused on resolution. He is tentatively on the late September trial calendar. Trial calendar would be called on September 20th. and then it's a few trial weeks after that. But if I preserve Mr. Fields' final plea rights, in other words, he could still withdraw his plea if I sentenced him to more than what you had negotiated for. Is that a workable outcome for you?
Yes, Your Honor. Why I was asking for that time is because discovery was a lot. And in between those, like right now, Monday, I start a special set murder trial in Coweta. Then the 21st, I have a double homicide special set in Upson. And then the remaining months after, so October, September, and December, I have a special set murder. So I'm pretty booked on those the remaining of the year.
Okay, I see your point. And so even if we didn't say that we would likely try Mr. Fields on that September calendar, you might have trouble just getting through the discovery and getting with Mr. Fields because of all your other obligations.
Yes, Your Honor. And it's unfortunate, but these are all 2018-19 cases that they're all now saying, let's just try it in 1 year.
Yep, that's what we're trying to do, is get through those older cases. Well, why don't we'll do one final plea reset. And then if for whatever reason that's not enough time because of the things you've just described, I'm going to move it to the trial calendar, but I'll preserve the final plea rights if you haven't gotten through the discovery. If you've gotten through the discovery and Mr. Fields just doesn't like what the state's offer is,
I'll
okay.
make that announcement, Your Honor, for sure.
Okay, so we'll further notice this to a final plea. You should know, if you haven't figured it out already, that Mr. Hiles is real good at saying, hey, I know it's 2 terabytes of discovery, and you're welcome to look through all of it, but here's the really sexy stuff that is bad news for Mr. Fields. Obviously, that's what you want to focus on, and he's good at highlighting that, and that might streamline some of your prep work. And I'm making this up, if there's a video of Mr. Fields saying, I did all these things, Mr. Hiles will show you that video, and then that'll help you focus your client on what may make sense.
I appreciate that. He's definitely been helpful thus far, Your Honor.
All right. So we'll further notice this to one more final plea calendar and take it from there. Anything else, Mr. Benchita?
That should be all. I appreciate that, Your Honor.
All right. Mr. Hiles, was this your only set of cases on the calendar?
Yes, Your Honor, it is.
All right. You guys are both free to go.
All right. Thank
Have
you.
a great one. Thank you, Your Honor.
I'm gonna make the call downstairs to my guys and tell him.
He can roll.
Any spectrum, any roundabout time? Just tell them further notice to try out.
You can tell him whatever you want. No, it's further notice to final plea. Yeah, so more than, yeah, say a month.
Okay, I'm calling that. Thank you, Judge.
Yep. All right, we got about 10 minutes-ish. Let's see if there are other final plea things we can work through. We're not doing Mr. Walker today, I believe. Is that right? Is being reset. Was it your sense that things were maybe moving towards resolution, but it's complicated partly for Mr. Walker needing the ASL or beyond, but also I think a parent of a victim, alleged victim?
Yes, Your Honor. ADA Willingham here on behalf of ADA Shapiro. That is correct. That there are lots of complicating factors, but one being that we do need a ASL interpreter for the victim's mother. But I do think from Mr. Shapiro's notes, it looks like it is on track to resolve.
Okay. What's a reasonable reset time? A month out? Okay. And we would be resetting it for final plea? Okay. And do you have the resources you need to communicate with Mr. Walker? Okay. Great. Okay. I don't know that he was brought over, but I know we didn't line up ways to communicate with him. So, okay. All right. How about Mr. Smith? He's here? Okay. If you need to chat with him, you can do that during the break we're going to have, the human trafficking break. But I will write down likely plea. Ms. Willingham, is that your sense?
Well, Judge, yes, sure.
Great.
I mean, there was an offer made. I know Miss Feely's been quite busy, so we hadn't gotten back and forth yet. But yes, I'm prepared to take a plea on that.
Great. How about Kendarius Lowe?
Same announcement, we're open for plea today.
All right, likely plea. Great, you two are going to be busy. Devontae White.
Mr. White, Your Honor, and that's what was with him as well, and we are ready for a plea sign up today.
Great. Are you Ms. Allen?
Yes.
Great. Okay. We will do that after the break. Thank you for being here, Mr. White. Don't go anywhere. I mean, during the break, you're welcome to go outside, but make sure you stick around. Alex Philemon.
That should be a plea as well.
Mr. Peoples, you agree, plea?
Yes, Your Honor.
I better get off this call fast. Dang. All right. Kevin Rouse. Hey, Mr. Rouse.
I do need to speak with him, so if we can come back to this one when we get back.
Okay. If it's not going to be a plea, cut in front of everyone so we can get on the record what the offer is and he can get out of here. All right. Ronald Rosario.
Here.
He's here. All right.
This is not a plea, Judge.
Okay. Mr. Rosario, if you could, there you are. Let's get you big on the screen. Excellent. You plus a little one. So let's get this on the record. Ms. Rivers, are you ready?
I am.
Great. This is position 9 on our final plea calendar, State versus Ronald Rosario, 23 SC 186842. Ms. Wood, do you have all the discovery you're aware of in the case?
We do.
And we have crime labs?
I believe so, Judge. I'll double check, but I'm pretty sure we do.
Okay. That's not something you've been worried about.
No, Judge.
Okay. And do the crime labs make it plain that the weight suffices for trafficking?
Yes, sir.
Okay, and then some. All right. Mr. Peoples, what is the state's offer in Mr. Rosario's case?
Your Honor, at this time, it's a tier 1 trafficking offer, which means that the state would have been offering at this time 15 serve 10. I believe that Attorney Wood and I may have something later for the court, but at this time, the offer is the mandatory minimum.
Okay. Mr. Rosario, do you understand that if you were to enter a plea today to the only count of your indictment, the state would be recommending what is right now, I think, the statutory mandatory minimum, which is 10 years to serve, followed by 5 years on probation? Do you understand that that's the state's recommendation?
I do.
Okay. Is that a plea you're interested in taking at this time?
No.
Okay. Do you understand that today, if you did enter a plea and I were to sentence you to more than what your lawyer asked for, you could withdraw that plea with no questions asked?
Yes.
After today, you still can enter a plea, and that may be how you choose to resolve things, but you will not be able to withdraw your plea if I sentence you to more than what your lawyer asks for. Do you understand that?
Yes.
The state's offer today is what I just told you, 15 serve 10, balance probated. That's their offer today. It may get better, it may get worse, but that offer expires today. Do you understand that?
Yes, sir.
Okay, understanding all those things, would you like me to move your case to the trial calendar? Let me put it differently. Either you enter a plea today, which you don't want to do, or I move your case to the trial calendar. You understand that's the next step?
Yes, sir.
Okay. Your case will be on the September 20th trial calendar. You'll need to be here in court without that little one on September 20th if your case has not been resolved before then. Understand?
Thank you, sir.
You're welcome. One last thing. Let me make sure we've got a good current address. I've got an address of Peachtree Street?
300.
Yeah, what is there?
It's my condo.
Okay. So you're not far. You could have walked here. All right. So that's your address.
Yeah.
Okay. and you just keep complying with the conditions of your bond. Ms. Wood will be in touch with you. Ms. Wood, anything else on Mr. Rosario? All right, then we will move your case to the trial calendar. You are free to go, Mr. Rosario. What's your child's name?
Halo.
Halo. All right, you and Halo have a good time.
Thank you, sir.
All right. Last is Antonio Edie.
Yes, Your Honor.
Hey, Mr. Williams, how are you? Let's get Mr. Edie. He was somewhere. Mr. Edie, where are you?
I think that was the last person speaking.
Oh, he was talking to us. Okay, where's Mr. Edie?
Well, we have Mr. Peters, I think he was excused from today.
Okay. Mr. Peoples, why would Mr. Edie be excused from today? He's got a real serious charges. He's on bond.
Your Honor, this case is very likely going to result in a null pros. I've spoken to attorney Deputy Abadi as well as Deputy Davenport. My understanding is that this case has there was a superseding indictment that sort of took care of all of this. There's just one thing that has to be done. I'm going to reach out to the victims, and then I received approval today to null pros this case.
A superseding indictment of someone other than Mr. Edie, or Mr. Edie is being reindicted?
No, Mr. Edie, my understanding is that Mr. Edie took a plea to a federal case that involved some of the allegations in this indictment.
Okay. What do you want to add?
That's about it. He was communicating with the AUSA, and so we're just getting all that resolved.
Did you represent Mr. Edie on his federal case?
I did not.
Okay. Is he in federal custody?
He was.
He's done with that?
Yes.
Okay, got it. Okay. So what's the next stop for this, Mr. Peoples? Should we put it on another calendar? I don't want to lose track of it, and then we don't follow through with the null process if that's where it's going.
Right. No, Your Honor. I'm going to reach out again to the victims today, and I'm going to submit the appropriate order today.
Okay. Mr. Williams, if it's not null prost, it is on the soon to be published September trial calendar. So you'll want to make sure, Mr. Peoples, if null prost is where the district attorney's office is going with it, that they do that. If that happens in the next few days, the calendar hasn't been published yet, and Mr. Edie's case will fall right off of it, and you'll be all set. Anything else?
That's it.
Okay, great. You may. Thank you, Mr. Peoples. We'll look for that null pros. I need to go get on this human trafficking call. When I get back, if we're going to release Mr. Rouse, let me know that. Otherwise, we'll start taking pleas, and you guys can arm wrestle as to the order in which we take the pleas. Let me see if there's everyone on the call is part of the team. Mr. Bagwell is back on the call if you want to figure out why that is. Oh, it's a plea. Okay, fantastic. I'm going to mute the microphone here in court. You ready? Thanks everyone for your patience. What order do we want to do this?
Judge, may I jump in and do the final plea for Mr. Rouse, who's out? It's not really a plea yet.
Okay. So I'm presiding next week, and these are all Rule 22s for the people who want to sit in the courtroom to watch DeAndre Royals walk in with a stack of papers. And I look at them and I hand them back to him because they're all right next door and 2 doors down in Judge Ellerby's courtroom this week.
Do we have any bond motions? Do we have any bond hearings?
Today?
No, for your presiding.
2, one with Marvin Arrington and one with Jackie, and he's now legally changed his name, Jackie the Fly Lawyer. It's how he actually signs it that way. It's his legal name.
The Fly Lawyer Patterson.
Yeah.
For so-and-so.
Oh, well, those are the 2, only 2.
Jacoby Moody then. That's.
So you can palm that off on someone else?
No, I'll be there.
Let me find the calendar. Oh, here it is. Mr. Rouse. All right, let's get on the record now that we're back. Ms. Rivers, you with us? I know you're with us. You ready?
Yes, I'm with you.
Great. Okay, this is position 8 on our final plea calendar. State versus Kevin Rouse, 23 SC 186840. Mr. Rouse is charged with burglary, terroristic threats, attempted aggravated assault, cruelty to children, and criminal trespass. Ms. Wood, this is your case?
Yes, Judge.
Do you have all the discovery in the case?
Yes, Judge.
Okay. And an offer. Ms. Willingham, what is that offer? If Mr. Rouse was going to enter a plea today to what would he be pleading and what would the state's recommendation be?
He would be pleading to counts 1 and 5. As to count 1, it would be 4 years probation, and as to count 5, it would be 12 months probation to run concurrent with count 1. All other counts would be non-prob.
All right. So in effect, 4 years probation for burglary.
Yes, Your Honor.
Okay. I know criminal trespass is in there, but that's the misdemeanor. And all the other stuff is dismissed. Okay. Mr. Rouse, do you understand that if you were to enter a plea today, it would only be to burglary and criminal trespass, and the state would recommend 4 years probation? Ms. Wood could recommend less, but all it would be less probation than 4 years. It doesn't involve any jail time. You understand the state's recommendation? Do you understand that if I sentenced you to more than what your lawyer asked for, so I'm gonna make it up, but maybe she recommends 2 years probation, and I say, no, I'm going with the state's recommendation of 4 years probation, that's more than 2. So you'd be able to withdraw your plea if that's what I did. Do you understand that? After today, you're always welcome to enter a plea. But this offer from the state about dismissing most of the counts and recommending 4 years probation for the other 2 counts, that may not be their offer in the future. It may get better for you, but it may get worse. They may offer prison time or who knows what. You understand that? And after today, if you decide to enter a plea, you can do that, but you don't get to withdraw it if the sentence I give you is worse than what your lawyer asked for. Understand that? Okay. Understanding all those things, are you interested in resolving your case by way of plea today, or do you want me to move your case to the trial calendar? That's what I'll do. Let me see if you are already on our, I bet you are, but let's just confirm, our September trial calendar. Survey says yes. So you'll need to be back here on the 20th. You'll get notice, September 20th, for the trial calendar. And if your case hasn't been resolved, then we'll have a jury figure it out. Any questions? Ms. Wood, you have good contact information for Mr. Rouse?
Yes, Judge.
All right, then he is free to go, and I will move his case to our trial calendar. All right, so we've got Smith, Lowe, White, Philemon, and Vaughn. Let's do White.
Mr. Wood, would you mind turning on your microphone, please?
Yes.
But Ms. Allen, if you'll come to the podium and we'll get Mr. White.
Oh, that's right.
Yeah, he's here. You can go on. Mr. White.
Ms. Willingham, are you ready on Mr. White's case?
Your Honor, I would,
Judge,
I'm sorry. Yes?
I'm so sorry. I would hate to jump the line. I have to go pick up the young man shortly. If I could just skip the line for Philemon.
I'll stand in for him.
Mr. Abate will handle it, okay?
Okay, I'll send him the information.
Thank you, Mr. Abate.
Thank you.
Let's move forward with position 6. It's State versus Devontae White, 23 SC 186316. Yeah, I'm gonna put Ms. Willingham on the screen there so you can see her, Mr. White. Ms. Willingham's gonna put you under oath in just a moment. Once you are under oath, please answer her questions and mine truthfully and completely. If you've got questions of your own, it's real important that you let Ms. Allen or me know, because I need to make sure you're following what's going on. So if something doesn't make sense, or wait, that's not what Ms. Allen said was going to happen, will you let me know?
Yes, sir.
Excellent. If you could bend the microphone towards Mr. White, I need to make sure the court reporter can hear him. When you're ready, Ms. Willingham.
okay. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name, your age, and your date of birth. You can put your hand down.
Devontae White. I'm born 1995, November 21st. I'm 27 years old.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
I graduated high school.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights: the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is 3 years probation as to a plea to terroristic threat. Is that what was explained to you?
Yes, ma'am.
For special conditions of that plea, you would also have to have no violent contact with the victim, complete family violence intervention program, complete an anger management program separate from the family violence intervention program, and complete 60 hours of community service. Was that explained to you as well?
Yes, ma'am.
Okay. You're pleading guilty today to terroristic threats, which has a minimum of 1 year and a maximum of 5 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
The negotiation in this case is 3 years probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 5 years?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to, you are not to violate the criminal laws of any governmental unit. Under the special conditions, and Your Honor, I would like to correct that. It's not no violent contact. It's actually no contact with the victim. And I recognize they share children. It will be communication through a third party, which I believe in speaking with the victim earlier today, it is through the defendant's mother.
Okay.
And Your Honor, if I could pause, because our last conversation with Ms. Willingham was no violent contact. So that's what I related to Mr.
When I spoke with the victim does not want contact with him at all. She would like for the communication to be through his mother.
So we'll cover, hold on, we'll cover, I promise we'll talk about that. In the end is my decision. But I want to get input from both sides, and Ms. Willingham is providing the input from your child's mom. But I'll certainly hear not only from Ms. Allen, but you may have something you want to share with me as well, Mr. White. So I put that on my list of things we'll cover. Let's keep going.
Complete the family violence intervention program, complete anger management, and complete 60 hours of community service. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offense to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Okay, Your Honor, if you just give me a moment, I'm going to switch over to the facts of this case.
Okay.
My apologies, it's pulled up on my screen somewhere, but I don't remember which screen, so it's just easier to start over. Okay. If this case were to proceed to trial, the state would prove beyond a reasonable doubt that on Sunday, May 1st, 2022, at approximately 2020 hours, while working the front desk at the Zone 3 precinct located at 2353 Metropolitan Parkway, Ms. Jessica Wilson walked inside the precinct requesting to file a report in regards to her children's father threatening her. Ms. Wilson advised that she was talking to her children's father, Mr. Devontae White. Ms. Wilson advised that Mr. White asked her if she could give him a ride to a job interview. Ms. Wilson advised that she declined his request for the ride. Ms. Wilson advised that Mr. White became upset with her. Ms. Wilson advised that she blocked his number from calling her. Ms. Wilson advised that she received numerous calls from different numbers and she didn't answer. Ms. Wilson advised that Mr. White went on Instagram telling her, "Wait until I bury my grandma Saturday, I'ma kill you." Ms. Wilson advised that Mr. White went on to say, "You'll never try me in life again. Wait till I bury my grandma." Ms. Wilson then advised that Mr. White does have a gun and she's in fear for her life. Ms. Wilson wanted to have the incident documented. And Your Honor, Ms. Wilson advised that at the time of this incident, she was located at 627 Alma Drive, Southwest Atlanta, Georgia, 30315 here in Fulton County. I have had an opportunity to speak with her on multiple occasions. In my last communication with her, it was actually earlier today. She gave me a call knowing that this was on the calendar and she asked that it be no contact. She does understand that the parties do still have children together, and she stated that for now they have been communicating through his mother, and she would like to keep it that way. which is why I'm now asking for no contact versus no violent. I do concede that it was the state's original offer of no violent contact. That's based on my original communication with Ms. Wilson. But in honoring the victim's wishes, I did want to make sure that it was on the record that she is requesting no contact at all.
Okay. Got it. Anything else?
And further from the state, Your Honor.
All right. Ms. Jackson, you're back.
Yes, Your Honor.
We did get you this afternoon. Did you end up getting the calendar?
Yes.
Great. What is the criminal history, if any, for Mr. White?
The defendant has 4 cycles. The last arrest was January 24th, 2003 with the City of Atlanta Police Department for aggravated assault. There's no disposition for that arrest. The defendant did receive first offender treatment in 2017 for Terroristic Threats Act. That case was sealed November 19th, 2019. Nothing in addition, Your Honor.
Thank you so much. Ms. Tucson, it doesn't sound like there's any open probation for Mr. White.
No open probation, just the one Miss Jackson mentioned.
Okay, thank you. Ms. Allen.
Yes, Your Honor. First, I did want to put on the record that the January 3rd, 2023 charge that was just addressed regarding Mr. White was, there was a declination of prosecution filed by the DA's office in this case already. I was going to be representing him on that matter, but it is effectively dismissed to our knowledge at this time.
Okay.
Otherwise, as I guess the court is already aware, the victim in this case, Ms. Wilson and Mr. White, do share 2 children together. They haven't been together for quite a while, and they've been experiencing issues co-parenting based on several things, including there's been problems with Ms. Wilson's boyfriend, who has previously been convicted of abusing Mr. White and Mrs. Wilson's children. So I think there has been a strain in the relationship as of that. But nonetheless, Mr. White is an active father, has always been an active father until this case, because he has had a no contact provision with Ms. Wilson. Our concern with the no contact provision in this case is that Ms. Wilson continues to contact Mr. White. Recently via Instagram, she sent him a video of the children after, I guess, his mother was not responding as she liked him to. And the prior charges always relate to when Mr. White is not speaking to her, then she takes her own routes to, get him in trouble. So I think it's understandable of why we were asking for a no violent contact provision in this case. Mr. White is excited to do the family violence intervention program. He voluntarily asked me if he can complete an anger management class along with that, because usually I understand that anger management is kind of in the family violence program. Right. He wants to do what he can to get himself together, to continue being a great father to his children and figure out how to co-parent with somebody who it has been rough for him to do, but he does want to move forward. And for all those reasons, we are asking the court to accept the negotiated plea today with the contingency of the no violent contact provision.
Okay. Mr. White, so you have 2 kids with Ms. Wilson.
Yes, sir.
How old are they?
9 and 10.
9 and 10. Boy, girl?
Both boys.
All right. And they primarily reside with Ms. Wilson.
It just started like that. They've been going to school with me and my mom from our home.
Okay. So recently, meaning maybe after this case was brought or you got your bond, when did they start living just with Ms. Wilson?
When the guy who beat my kids came back in her life.
Then your kids started staying with Ms. Wilson and this guy.
Yes, sir.
Okay. So right now, under the bond, you can have no contact with Ms. Wilson?
I'm not on no bond.
Well, for this case, yes, that's correct. No.
Right, you're on a bond.
Okay.
Yeah, I mean, you're on a bond, but are like, is it consistent with the bond? You could call Ms. Wilson right now and say, hey, I want to come see the kids.
Yes, but I don't do none of that.
How do you see your kids?
I don't.
You don't? When did you last see them?
She sent one of my sons like a month or 2 ago when I got out. But I'm legitimizing everything, and she took him out of school without me knowing, so I don't know how to go about that.
Okay,
But
so
like-
you're gonna work through some family law remedies to legitimize and then assert your parental rights.
Yes, but I want to ask you a question.
Hmm?
She don't want no contact, but she texting me and she comes to the house.
Right. So I hear you. And Ms. Allen mentioned that, and that's a complicating factor because let's say it's no contact. That's not meant to be a trap for you. And so it would not be okay for Ms. Wilson to show up. You're walking down the street and run up and quickly take a picture and say, look, he's in the same picture with me. He had contact with me. So it sounds like it's complicated. So you last saw one of your sons a couple months ago, but that's just because Ms. Wilson.
Through
your mom. Okay, is that your mom right there? Okay, ma'am, is your last name White? Allen.
No relation.
Okay, Ms. Allen, what has your experience been in terms of Ms. Wilson relying on you so that your grandsons could spend time with your son? And I didn't mean that to be vague, but does she reach out to you to say, hey, I want to make sure the boys can be with their father, so could you come pick them up? Or how has that worked, if it's worked?
She just had them for this school year, to this case.
Yeah.
They had been with me. And their relationship, they good one minute and they bad one minute. You don't go along with her, she go to the court, she gonna be terrorist, she gonna be a PTO, and she dropped. The last case is he on here now, she advocated for him to be a bond.
Okay, but I hear you.
The kids.
The kids.
She come through me.
Okay.
She just come, we just seen
DeAndre.
for June. All right, she called me the middle of July, asking for school shoes, but she's been calling through me.
Okay.
I talked to him, but everything she does.
It goes through you.
It goes to me when Deontay came.
DeAndre.
When DeAndre came to the house, I dropped him off.
Okay.
Instead of letting her come to my house, I decided, we met up at Whale Park, at the parking lot.
Yep.
So that I wouldn't get him in trouble.
Yep.
So that's what I've been doing.
Okay.
So I'm just over between.
Okay. So here's, I'm going to address this, I promise. So, but I just want to make sure we move this forward. So first, I find there's a factual basis for your plea that in May of last year, you did this thing. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. You've got great advice from your lawyer, Ms. Allen, and you've decided to go forward with the plea, and you understand the consequences of the plea. Is that fair?
Yes, sir.
Okay. Do you authorize Mr. White, my staff, to sign the indictment on your behalf, indicating your guilty plea?
Yes, sir.
Okay. And can they sign on your behalf, Ms. Allen?
Yes, Your Honor.
And Ms. Willingham?
Yes.
Okay, great. Mr. White, I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, which you will be for a few years, if you have a minor violation, you and probation will work that out. You don't have to come see me. But if it's a big violation, you get arrested again, or it's documented that you had either violent contact or contact with Ms. Wilson, that comes back to me. But you miss a meeting or something, and I don't want you to, but if you do, probation and you will sort that out. I am going to sentence you to 3 years probation to the one count. I am going to make it a special condition of your probation that you complete a family violence intervention program. I'm not going to require anger management because that's part of the FVIP. That's actually a bunch of classes, and a lot of it is anger management and how to work in a relationship where you don't end up saying, I'm going to kill you after I bury my grandmother or something like that. So that'll be enough, I think. I'll require you to do 50 hours of community service. And we're going to start out with no direct contact with Ms. Wilson. But I'm going to ask Ms. Allen to reach out to me, and Ms. Willingham needs to reach out to both of us, if that is not giving you access to your kids. And the way it'll work is you'll work through your mother, Ms. Allen. If you want to see your boys, Ms. Allen would reach out to Ms. Wilson saying, hey, Mr. White wants to be with the two boys. How do we make that happen? And if Ms. Wilson's like, I'm not doing that, if it's not working out that way, this Ms. Allen, lawyer Ms. Allen, needs to reach out to me. I'll modify the sentence so that you can directly contact Ms. Wilson. But right now, I don't think the issue is who's contacting Ms. Wilson. It sounds like there's this other boyfriend, there's legitimation issues. And last thing, and I promise you can talk, I know she's reaching out to you. You need to not respond, whether you change your phone number, whatever it is. And your mom can help explain that to Ms. Wilson. But if things go smoothly for a while and either Ms. Wilson reaches out to Ms. Willingham, the prosecutor, say, no, it should be so much easier if Mr. White could call me directly. I'll certainly modify it that way. But it could be I modify it at your lawyer's request because it's just Ms. Wilson's making it too difficult. She's either not responding to your mom or who knows what. But I want to keep this as safe as possible for you. And the simplest rule is don't contact Ms. Wilson. Now, her texting you is not you contacting her. If all she can show me is, look at all these times I texted Mr. White, my response to her would be knock it off. Because right now the two of you need to be moving in different circles. That's complicated because you have two boys together. And that's why I'm willing to modify this, but I want to see everything be stable for a few months. And if it goes smoothly, like I said, it may be that Ms. Wilson says to Ms. Willingham, hey, I need him to be able to, I need to be able to drop the boys off with him. I want him to be with the boys and me at their birthday or whatnot. But for now, that's not how we're going to work it. Just so it's a real bright line rule. It's not meant to be a trap. I'm not going to revoke your probation because Ms. Wilson runs up on you and takes a picture. But if she's got cell camera footage of you breaking a bottle on the front of her car while she's in the car, I'm going to put you in jail. So it should be pretty clear what you need to do. Most of all, I want you to be present in your son's life. And that's why I'm open to modifying this if Ms. Wilson's making that difficult. But you've got a little family law work to do in terms of legitimating and then asserting your ability because you have a right to parent the two boys. Okay. So, now, you've been itching to say something. I want to make sure.
Legitimized.
Oh, you are? I thought you said you were doing that.
No, I'm legitimized. I have my paperwork and everything.
Great.
Yep, so he just has to work through the next stage of the process.
Right, so then the next step is that a court needs to get involved. It won't be me. It'll be one of our family judges that says, no, wait a minute. There's a father and a mother. And so dad has rights too. And so is it every weekend? Is it every other weekend? Is it, and you can work that out with a court, but you've got a right to be with the boys.
I have a question. When I got arrested for my aggravated assault.
That's not what we're here for today.
Well, how about this? Ask Ms. Allen,
Yeah.
and then she'll let me know.
Like if she comes.
Can you whisper?
It's not a whisper. Why don't you guys just walk to that wall, that little wall right there? Just turn around and walk to that little wall, and then say it as quietly as you can.
All right, Judge, I don't know if there's an exact answer to this, and you kind of already have covered with your rule, but his concern is still that she pops up at their house. So prior.
When you say their house, does
Well,
Mr.
he
White
has a
live
home.
with Ms. with Ms. Allen?
Yes, he
Okay.
does. So I guess his concern was that with the no contact provision, he's scared if she pops up to the house, what does he do?
Right.
And I could advise him of my thoughts later on, but.
Sure. So it's your house. I appreciate it's probably your mom's house, but if she shows up at your home, that's her problem and not yours.
Okay.
Now, if you're at a McDonald's and she shows up, you got to leave the McDonald's, get a to-go bag and head out. But that would be a coincidence. If she shows up at your house, she's trying to get up in your business. Now, if she's dropping the boys off, this is where your mom's been doing it just right. Hey, well, let's go to the Wells Fargo. Let's go to this place. Or if your mom knows you're not at home because you're at work, she can come to the house to drop the boys off. But she, Ms. Wilson, should not be randomly showing up at a place where she knows you live. So again, this is not meant to be a trap. I'm not interested in revoking your probation because Wilson comes to White. But if White is messing with Wilson, you've made a bad choice.
Yes, sir.
Okay. I know that's a little murky. I don't mean for it to be murky, but these exes with shared kids, it's complicated. You've got a good resource with your mom. You've got a great lawyer. And you may want to explore figuring out the parenting plan through a court where a judge orders, no, Mr. White gets the boys every weekend or every third month or whatever the deal is. And then there's a rule everyone has to follow. And you can enforce those rights if that's not what Ms. Wilson does. But my hope is she puts the boys' interests ahead of her own and makes it easy for you to spend time with them. And this is how I'll end it, other than you're going to have to get probation reporting instructions. I'm happy to revisit the no contact provision. If for a few months things go smoothly and Ms. Allen talks with Ms. Willingham, like, you know what, it'd just be simpler if White and Wilson could speak directly about arranging visitation with the boys. I'm happy to change that. Okay.
Yes.
All right. Let's get your reporting instructions. Ms. Tucson?
Hi, good afternoon. Mr. White, where do you live? What's the city?
The county, Fulton County.
It's Fulton County. Okay. What is your phone number and address? I'm gonna call you and give you reporting instructions.
678-907-6911. 339.
678-907-6911.
Yes.
Okay, and what's your address?
339 Holden Street, Southwest Atlanta, Georgia, 30310.
Okay, got 3390.
339 Holderness.
Like HOLDER?
Yes. NESS. Yes.
Okay, and then I'm gonna have your reporting date at August 24th at 10 a.m.
Yes, that's a good time.
Okay, and then I will give you a call to confirm that, okay? The address is 276 Memorial Drive. It's right around the corner from the courthouse.
Okay.
Okay.
Anything else, Ms. Willingham?
Nothing from the state.
All right, Ms. Allen, anything else?
Nothing from the defense, Your Honor.
Thanks for your time. All right, Mr. White, make sure you make it for that probation reporting.
Okay, I will.
Great. See you around.
Thank you so much, Judge.
Ms. Wood, Ms. Feely, what's next?
Judge, if we could make an announcement on Philemon.
Oh, okay. I thought we had
Oh, we're close, Judge.
so it's a final plea. We should bring them out. Okay.
I just want to let you know it's not going to be an actual plea today.
Not an actual plea, a virtual plea.
Excuse me, Judge.
Yes, ma'am.
Can you type this document in?
I will take that. Yep, I'll make sure it gets filed. Thank you.
Thank you so much.
Sit in that middle chair right there. Between both councils.
All right, Mr. Abate, I'm gonna ask you to stand in for Mr. Peoples on this position 7, Mr. Philemon. Do you need the case number?
Yes, Judge.
It's 23 SC 186 547. All right. So we'll go on the record for this. It's State versus Alex Philemon. Am I saying your name correctly?
Yes, sir.
Excellent. Mr. Philemon, you're charged with arson. And I had been talking with your lawyer and the prosecutor, and I thought maybe your case was working out today. Sounds like not quite, but maybe we're close. Ms. Wood, it says Ms. Feely on here. But I'm going to ask you because you've been doing the talking.
Yes.
Do you or does the public defender's office have discovery in the case?
I believe we do, Judge, and we have an offer, and it's close, just Ms. Patterson needs a bit more time. We don't want to set Mr. Philemon up for failure.
Okay. Mr. Abate, do you know what the offer is, or should I ask defense counsel and you'll trust their representation?
I will trust the representation.
Okay. Ms. Wood, what is the offer that you understood the Mr. Peoples to have made?
It is 10 served to Judge with a few special conditions.
Okay. Balance probated.
Balance probated.
Okay. Mr. Philemon, if you were to enter a plea today to arson, the prosecutor would recommend that you serve 2 years in custody. You get credit for all the time you've been in, and you've already done more than half a year. And then you'd be on probation for 8 years. And it sounds like there are a few special conditions of that probation. Do you understand that that's the state's recommendation?
So that's what they were gonna ask for today, remember, and we were gonna ask for something else, so that's the state's offer. Do you understand that's what they would be offering?
So 2 years consideration.
In custody, yes, sir. That's their offer. That's what we do. Right.
But do you understand that that's what they would ask for?
So, Mr. Philemon, I'm not asking you if you like it or if you're going to take it. I just want to make sure you understand if you decided, Judge, I'm pleading guilty, I set this thing on fire, I'm going to plead guilty. The prosecution today would recommend that you serve 2 years in jail, followed by 8 years on probation. Do you understand that?
Yes, sir.
Okay. If you were to enter a plea today, Ms. Wood could recommend something different. If I sentenced you to more than what Ms. Wood asked for, you could withdraw your plea. So if she asked for time served, maybe 6 months, because you've already done 6 months, and I said, nah, I'm going to sentence you to a year, that's more than time served, you could back out. You could say, no, thank you. I was willing to do time served, but I'm not going to do a year or 2 years. Today, you can back out like that. Do you understand?
Yes, sir.
Okay. After today, you can certainly enter a plea, but you don't get a back out if you don't like your sentence. Do you understand that?
Yes, sir.
Okay. Understanding all those things, Mr. Philemon, do you want to go forward today with a plea, knowing that the state's going to recommend 2 years? Or do you want to have me put your case on a trial calendar? Your case may still work out. It doesn't mean you're going to trial, but it keeps your case moving forward.
Yes, sir.
You want me to move it to a trial calendar?
No, sir. I'll take the plea.
You want to enter a plea? Okay. Ms. Wood, you want to chat real briefly with Mr. Philemon about that? Okay. You want to chat back there?
Yes, Judge.
Okay. Let's have that focused conversation.
I'll do the enforcement. Okay, that's fine. So, yeah, that's right.
Do we have enough deputies that we could bring out?
Judge,
Excellent.
you do this.
So
Sergeant Florence has just arrived.
fantastic. Ms. Feely, what plea would you like to take?
Antoine Smith.
All right. So if we could bring out Mr. Smith when you have a chance.
Sergeant Florence, you back there. Oh, no. That's it. Okay, go to the podium.
Hey, Mr. Smith, come on up to the podium, please.
How you doing, sir?
I'm okay. How are you doing?
I'm all right.
Good. Ms. Willingham, you ready?
Yes, Your Honor.
Great. We'll go on the record with position 423 SC 186197, State versus Antoine Smith. Mr. Smith, you're charged with aggravated battery, aggravated assault, and battery. And Ms. Feely tells me you're ready to enter a plea. You ready to go forward?
Yes, sir.
Okay, Ms. Willingham, who you see on the screen there with all those fancy books with her, she is going to put you under oath in just a moment. Once you're under oath, you'll need to answer all of my questions and her questions. You ready to do that?
Yes, sir.
If you have any questions or you're confused by anything we talk about, will you let your lawyer or me know?
Yes, sir.
All right, Ms. Willingham, when you're ready.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name, your age, and your date of birth, and you can put your hand down.
Antoine Tremaine Smith, 31076. What else? Spell what?
And your age.
Yeah, how old are you?
Oh, 47. I'm sorry.
That's okay. I don't know why they asked you
I'm sorry.
both. I want to know how many years you are and not do the math. 47 years old. How far did you go in school?
10th grade.
Okay.
But I got my GED though.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case, as to count 1, is 5 years to serve 1 year with the balance probated. Count 2 would merge into count 1, and as to count 3, serve 12 months. Is that what was explained to you?
Yes, ma'am.
And I'm sorry, the special conditions of this would be no contact with the victim, complete family violence intervention program, and complete 100 hours of community service. Did your lawyer also explain that to you?
Yes, ma'am.
Let me just double check the email. I think I can relate to
No
him.
violent contact.
No violent contact.
You're correct. I'm sorry, Judge. I swapped those 2 cases up, but yes, no violent contact on this one.
Okay.
You're now pleading guilty. You're pleading guilty today to aggravated battery with a minimum of 3 years and a maximum of 20 years. Battery with a minimum of 1 day and a maximum of 12 months. And aggravated assault, although it merges, would have a minimum of 3 years and a maximum of 20 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
I'm on probation. Fulton County.
Okay. And do you know whether you have had any proceedings for that already?
Do you know if
No.
you haven't had a revocation hearing or anything? Well, we'll get that case number and make sure we wrap that up today as well, assuming that's what you want to do.
Okay. And I'll read it. I know Judge just addressed it. We'll address it at the end, but I'm going to go ahead and read the next line to you just so that you'll have that understanding. Do you understand that by pleading guilty today, that your probation or parole will almost certainly be revoked?
Yes. Yes, ma'am.
You heard me tell the court what the negotiation is in this case, which is a total of 5 years to serve 1 year with the balance probated. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law?
Yes, I understand.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no violent contact with the victim, complete family violence intervention program, and complete 100 hours of community service. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any forced threats or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No. No, ma'am.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offense to which you are pleading guilty?
Yes, ma'am.
Are the facts of this case, are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You have 4 years from the date the sentence is entered for the felony offense, and you have 12 months from the date the sentence is entered for misdemeanor offenses to file this petition. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, I understand.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, I understand.
Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on November 6, 2022, Officer R. Taylor responded to 955 Central Avenue, apartment IL, Hateville, Fulton County, Georgia, 30354, in reference to a physical assault call. Upon the officer's arrival, he spoke with the complainant, Latoya Kilpatrick. She stated that she and her live-in boyfriend, the accused, Mr. Smith, were getting ready for bed when she asked Mr. Smith to take his leg off of hers. Ms. Kilpatrick stated that Mr. Smith refused to move his leg and swung at her, but missed. Ms. Kilpatrick stated that Mr. Smith strangled her, but didn't explain how he did it. Ms. Kilpatrick stated that Mr. Smith struck her above her right eye, causing a small laceration. Officer Taylor spoke with Mr. Smith, who stated that Ms. Kilpatrick was holding a hammer and he tried taking the hammer from her when he accidentally punched her in the eye. However, there was no hammer found at the scene. Mr. Smith was detained and transported to Hateville PD for arrest and booking process. Your Honor, in this case, I have not directly had an opportunity to speak with Ms. Kilpatrick. My investigator was able to locate her a few months ago, and we have not been able to get back in touch with her since then. She did relay to her what the state's offer was at that time, or at least what we were considering. We had not formally extended it, but we have not been able to reach back out to her since. We've made some contact with a few family members, but we have not been able to actually speak directly with her. She's not returning our calls.
Okay, thank you. Ms. Jackson, criminal history information for Mr. Smith.
Yes, Your Honor. The defendant has 10 cycles. The defendant's last arrest was April the 29th, 2022 in Fulton County for a probation violation. The defendant does have prior felony convictions. It's one in 2009 out of Cobb County for cruelty to children in the first degree. And there was an additional one in 2009 out of Fulton County for a charge associated with a CWAC. And there was one in 2000 for possession of marijuana with the intent to distribute and possession of controlled substance with the intent to distribute. He does have misdemeanor convictions, one in 2009 out of Cobb County for criminal trespassing, and one in 2005 for battery family violence. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, what do you have? And Mr. Smith thinks he's on probation right now. Do you have him on anything?
Yes, he's showing currently on probation at the moment for a case 09 SC 77856.
Okay, and what are the charges and how much time remains?
There is 2 years, 10 months, and 6 days remaining. It's a case from 2009. He's on the SBS unit, and it's for rape and aggravated child molestation. And it looks like he does have an active warrant for violation.
Okay, let's see.
And that was signed in December, and it looks like Judge Adams. That was one of Calhoun's. Yeah, so that's a Judge Adams.
So in September of last year, Judge Adams revoked a year of that probation and commuted it to time served because of a case out of Douglas County and some positive drug and alcohol screens. He was supposed to go into MADRC. There's a warrant from that 09 case that is more current than whatever resulted in the revocation in September.
Yes, this looks like a warrant from this warrant is dated December 7th.
Okay. All right, give me a second. It's a complicated case. There was an appeal. Jury charge error.
DRC. And I wasn't able to, so I just had to call this shit. I did start it one day.
Okay. Ms. Willingham, were you aware of Mr. Smith's? It's no longer a child molestation conviction. The Court of Appeals reversed the conviction on child molestation because of the way that Judge Adams instructed the jury. It created a variance between how the indictment was written and the charge that they got. But it is a rape conviction, 20 served 12 balance probated. Is that something you had looked at when you put together your recommendation here?
Judge, it was when I was originally trying to craft a recommendation. However, when the state lost contact with the victim, the recommendation that was then sent over reflects that.
Okay, got it. All right. Ms. Feely.
Thank you, Your Honor. So we are asking for essentially what the state's asking for. Mr. Smith is 47 years old now. He went to Tri-Cities High School, and as you heard, he did get his GED. He has been working off and on at Spondivit as a cook, like since he was 17. So for years and years, and he's very confident that he will be able to return to that job and start, as he says, getting his money going again so that he can get back on his feet. The no violent contact, they do share a child, and I think that that is kind of what the arrangement is. I think they've fallen upon hard times without Mr. Smith out there, and we have a different version of events than what Ms. Willingham has. However, for purposes of this plea, we are admitting to the elements of the indicted charges.
Okay.
So we are asking the court to consider, he has been in since November 6th of 2022. It looks like that warrant did hit in December of 2022 for the probation warrant. So we're asking the court to consider reducing the time to the time that he's already served. I don't know that he's going to learn anything or get any benefit out of another couple of months, but we're ready to move forward.
Okay, but there's also a warrant on, so whatever I do isn't gonna change his liberty status, because he still needs to get in front of Judge Adams in connection with the probation warrant. Is that correct?
I believe so.
Okay, all right. Mr. Smith, anything you want to add?
No, sir.
How many kids do you have with Ms. Kilpatrick?
1.
How many kids do you have total?
3.
Okay, how old is the child you have with Ms. Kilpatrick?
A year.
All right, and that child lives with Ms. Kilpatrick?
Yes.
When you get out,
He's currently with defects right now.
why is that?
Because she was staying with me at the apartment where the incident happened. And now I guess the apartment's gone, so she ain't had nowhere to go. So she was with her mother. And I think that her and her brother got an apartment together now.
Okay, but your child with Ms. Kilpatrick is not with her or her brother, but is in foster home or
Yeah,
defect?
and she's currently getting ready to get him back.
Okay. And when you get out, is your plan to be with Ms. Kilpatrick again or someone and somewhere else?
Well, yes, really.
Do you have a place to stay when you get out? Nope. Okay. Do you have family in the Atlanta area?
Yes.
Who?
My sister, my mother.
Okay.
I got cousins.
Would your mom let you stay with her, or that's not how it works?
She might.
Okay.
That's
all right. That's not a condition of getting released. I just was curious what your plan was. All right. Ms. Feely, do you waive any due process notice rights Mr. Smith might have? Oh, no, I'm not going to handle the revocation. That's going back to Judge Adams. Never mind. Forgot. Okay. Mr. Smith, I find there's a factual basis for your plea. I understand that it's probably a little different than what Ms. Willingham shared, which she only knows this from reading the police reports and maybe having a conversation with Ms. Kilpatrick. These situations are always a little more complicated. But it does sound like you and Ms. Kilpatrick got into it physically, and that's not ever the right outcome. And it really doesn't matter if someone had a hammer and someone didn't. You need to resolve these situations a little bit differently. You have a conviction for family violence battery. You've got a cruelty to children conviction. You know by now at 47 not to put your hands on folks, and you need to actually act on that. I also find your plea is knowing and voluntary. No one's forced you to enter this plea?
No.
Okay, and have you understood everything we've been talking about?
Yes, sir.
Any questions?
No, sir.
I'm sentencing you pursuant to the Probation Options Management Act, so that if you have a minor or a technical violation, you and probation will work through that. If it's more serious, you get arrested again, or you have any violent contact with Ms. Kilpatrick, that comes back to me. Ms. Feely, is it all right if my staff signs the indictment on your behalf?
Yes.
Ms. Willingham
Yes, Judge.
and Mr. Smith, can we sign it for you?
Yes, sir.
Okay. I will sentence you as to count 1, aggravated battery, to 5 years to serve 1 year with the balance probated. Count 2 merges into count 1, and count 3 is a misdemeanor, and your sentence for that is 12 months to serve. That'll run concurrently with count 1, and you'll get credit for the time you've been in. So you are almost done and may get released early, but I think that a sentence of 1 year to serve is quite reasonable, given some of the things I've learned today, but I understand why the state is coming in at that number now, and I will not go above it at this point. Special condition of probation number 1, complete a family violence intervention program. That's not one class, it's a series of classes. Number 2, no violent contact with Ms. Kilpatrick. That would be a crime anyway. But if you violate a special condition of probation, I could revoke all of your probation, just 4 years. And finally, you're going to complete 100 hours of community service. Don't worry, you don't have to do that all up front. You're going to get back to work, et cetera. I'm going to waive your probation supervision fees for the first 2 months so you can focus on earning and taking care. What's your little kid's name?
Sujan.
Sujan? How do you spell that?
Suejohn.
Sujan. All right. Anyway, you can focus on helping take care of Sujan once you all get Sujan back. You are still going to need to see Judge Adams and deal with that revocation. Ms. Willingham, anything else on behalf of the state?
Nothing from the state.
Ms. Feely?
No.
Ms. Tucson, what do you need to tell Mr. Smith, if anything, about probation in this case?
Well, Mr. Smith, you know where probation is in Fulton County, correct?
Correct. Yes,
Okay,
ma'am.
so this docket will be entered, and just make sure after the when you go before Judge Adams and your release, you do report for both cases.
Yes, ma'am.
Okay.
All right. Thank you.
Thank you. Thank you.
Next.
So I'm saying, so I bring them up.
Vaughn, Philemon, Lowe.
We can finish what we're doing with Philemon.
What is it that we're doing with Philemon?
Nothing, Judge, he understands now. I have talked to Mr. Body though about maybe a BHTC referral, and I'll get with Ms. Patterson as well, but it won't
Okay.
be a plea today.
It will not be today.
No, Judge.
Okay.
But we are going to get to Vaughn today, right, Judge?
Yeah.
Hey, I'm all for it. I don't know that he's here. I don't know that he exists.
He's here.
Okay. Can we bring Mr. Philemon? He's coming next. Okay. And then why don't we do Mr. Vaughn after that, just in case, so he doesn't like get whisked away to a black ops site.
That sounds perfect.
All right. And remember, we got Mr. Bagwell too. I don't want to forget that. He's very patiently on. Hey, Mr. Philemon, we just changed the setting a little bit. We're going to go back on the record in your case. I think there was a little confusion about, are you pleading today or are you going to move your case to a trial calendar, although we may still work your case out? Do you feel like you understand what's happening now? Do you want to enter that plea today, or do you want to have Ms. Wood and her team see if they can find a program, maybe even get you into one of our accountability courts as part of your plea?
Yes, sir.
That latter?
Yes.
The second one?
Yes, sir.
Okay, so no plea today.
No, sir.
Okay. Then I'm going to move your case to the trial calendar. That doesn't mean you have to have a trial, but that means we keep moving your case forward. And I hope that if we're able to come up with some, if you all are able to come up with some resolution, we'll see you before the trial calendar. Okay. All right. Thank you.
Thank you. So you can bring Vaughn next. Vaughn. Vaughn.
I hope he's back there.
And I actually have to read for childcare purposes today, but luckily Ms. Wood and I have been tag teaming all of these cases anyway, so.
As long as we've got a prosecutor and a defense attorney for the remaining cases, we are good to go. Try to find that calendar. There it is. No Monday.
Because I'm gonna follow Ms. Feely, but I'll be in my office. There's a need for a prosecutor.
Because you were here for Philemon and we just finished that. Sounds good?
Yeah, have a nice day.
You too.
Maybe, yes. Leave it. Okay. Just leave it on file. Yes.
Are you Mr. Vaughn?
Yes, sir.
Excellent. You've been hard to find. Not your fault. Okay, this is position 1 from our special plea calendar this morning. State versus Jacory Vaughn, 23 SC 187201. Mr. Vaughn, Ms. Wood tells me you're prepared to enter a plea to some or all of the charges in your case. Is that correct?
Yes, Your Honor.
Okay, the person you see on the screen there is Ms. Willingham. She's the prosecutor in your case, and she's going to put you under oath in just a moment. Once you're under oath, you're going to get a bunch of questions. Please answer all of them. If you've got any questions, you should tell me or Ms. Wood so we can answer those questions. Will you do that?
Yes, Your Honor.
All right, Ms. Willingham.
Okay. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. You can put your hand. Please state your name, your age, and your date of birth.
Jacory Vaughn, August 31st. And I'm 22.
Thank you. Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
Graduate.
A graduate.
Yes, sir. Yes, Your Honor. I'm sorry.
Okay.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am, I do.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am, I do.
The negotiation in this case, as to count 1, the state would be null processing. As to count 2 and 3, 5 years probation. As to count 4 and 5, 12 months probation. All counts to run concurrent. Have no violent contact with Alexis Johnson. Complete family violence intervention program. Complete 60 hours of community service. Is this what was explained to you?
Yes, ma'am.
You're pleading guilty today to aggravated stalking with a minimum of 1 year and a maximum of 10 years, theft by taking with a minimum of 2 years and a maximum of 20 years, battery family violence with a minimum of 1 day and a maximum of 12 months, and cruelty to children 3rd degree with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
Yes, here, misdemeanor.
You're on misdemeanor probation here in Fulton?
Yes, sir. Yes, Your Honor.
For what? Like, is it for jaywalking or domestic violence? What was the crime for which you're on probation?
Family violence.
Okay. Did it involve this same person whose name I just heard?
Yes, Your Honor.
Okay.
And Your Honor, the state was aware of that. I actually spoke with the SG who handled it, and I spoke with the victim about it as well.
Thank you.
You heard me tell the court, and I'm sorry, Your Honor, and that actually just happened. So they were aware of this case as well. So I don't anticipate it causing a revocation because it was this case was pending at the same time, and they were aware of it. So I don't think it's going to cause that, but just so that you know, a conviction could cause the revocation of your probation. Do you understand that, Mr. Vaughn?
No, ma'am. Could you explain that to me?
So, Mr. Vaughn, you've got your misdemeanor probation. When did you plead in that case?
last month, I believe.
Okay. This plea today should not affect that probation because the offense in this case happened before you were on probation. So Ms. Willingham is saying, I think the legally correct thing, which is this really shouldn't have an impact, but you should know anytime you get a new conviction and you're on probation, probation may suddenly say, hey, what's going on here? A lawyer on your behalf would say, what's going on here is something everyone knew about when he pled in state court because these charges were pending as well. Does that make sense?
Yes, Your Honor.
Okay.
Thank you, Your Honor. You heard me tell the court the negotiation in this case, which is a total of 5 years probation. Do you understand that the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 32 years?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no violent contact with Alexis Johnson, complete family violence intervention program, and complete 60 hours of community service. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am, I do.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am, I am.
Has anyone used any forced threats or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am, I am.
Do you have any more questions for your lawyer before we go on?
After I complete the class and stuff like that, what would it?
Your question is if you take care of all these conditions, can your probation end early?
Yes.
TBD, maybe. If you're doing well on probation, probation is going to want to be done with you because they have knuckleheads who are a pain. So it's always good to knock this stuff out. I need to hear a little bit more about you. I may set what's called a behavioral incentive date, which ends your probation early as well. So I'll make a note of that and we'll talk about it.
Thank you.
Sure.
Yes, ma'am. I understand.
Have you understood everything I've asked you so far?
Yes, ma'am, I have.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am, I do.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am, it is.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am, I am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for the felony offenses, and you will have 12 months from the date the sentence is entered for misdemeanor offenses to file this petition. Do you understand these time limits?
Yes, ma'am, I do.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony which carries up to 10 years in confinement?
Yes, ma'am.
Your Honor, if the state were to proceed with this case, the state would prove beyond a reasonable doubt that on September 4th, 2021, officers responded to 4001 Lakemont Drive, apartment 32F, College Park, Georgia, in Fulton County, regarding a domestic dispute. Upon arrival, officers met with victim Alexis Johnson, who informed officers that her boyfriend, the defendant, Jacory Vaughn, was involved in a physical altercation and her were involved in a physical altercation and he stole her vehicle. Vaughn and Johnson have a child together. At the time of the incident, Vaughn had been charged with battery family violence against Johnson. The special conditions of his bond order prohibited him from future contact with Ms. Johnson. On the day of the incident, Vaughn and Johnson got into a verbal argument that turned physical when Vaughn grabbed and pushed her as she was attempting to get away from him. Ms. Johnson stated that Vaughn continued to tussle with her and push her head into a wall and got on top of her. During the incident, their juvenile children were in the room, KS and XR. Ms. Johnson stated that she told her oldest daughter, KS, to contact the police, and Vaughn grabbed her car keys and ran out of the apartment. Ms. Johnson stated that she attempted to get her keys back by chasing Mr. Vaughn. However, he got into her vehicle and left. Your Honor, I have had several opportunities to speak with Ms. Johnson. She actually reaches out to me daily about wanting this case to plea so that the defendant can come home. I have advised her that with a stalking charge, I would recommend that they try and get a third party to help them navigate with the children, just because it seems that these issues continue.
Right.
However, she has repeatedly reached out to me, and she is eager for the defendant to come home. She's eager to have contact with him. And I recognize that if I were to put in place a no contact, it may bring us right back here. So I'm asking for a no violent contact at this time, even though it is not the state. The state doesn't think that that is appropriate. We would, like I mentioned, we would prefer it be no contact, but I see that that potentially will cause a big issue very shortly.
Okay. But this is the case where Ms. Johnson has been contacting you routinely, seeking a prompt resolution so that Mr. Vaughn can be reunited with her to help take care of kid.
That is correct, Your Honor.
Okay, thank you. Ms. Jackson, criminal history information for Mr. Vaughn, please.
Your Honor, is this Mr. Ja'Cory Vaughn for this morning?
Yes, ma'am.
Right. He has 7 cycles. The defendant's last arrest was May the 7th, 2022 in Fulton County for battery, family violence. He does appear to have open cases pending in Fulton County. One is for battery, family violence, and theft by taking, and cruelty to children. That case number is 21 CP 202-806. And there's an additional open case for battery, family violence. That case number is 22 CR 002814 and the letter E. Nothing in addition, Your Honor.
Thank you. The state court case, that's the one ending in the letter E, got transferred to Superior Court. I don't know that it ever did, but that is closed out as transferred to Superior Court. Ms. Wood, what do you have on behalf of Mr. Vaughn?
Thank you, Judge. He has been in custody since April the 14th, so 117 days. We would ask for credit for those days. He's 22. He's a lifelong Atlanta resident. He lives and will return to Rex, Georgia, a residence he shares with his mother and his siblings. He is a high school graduate. He does have children. And it's my understanding that he had gainful employment prior to this. He has his forklift operator's license. So we're hopeful that he can return to some warehouse work upon release, and we would just ask that you accept the state's recommendation.
Mr. Vaughn, how many kids do you have?
1.
One, and that's a child you have with Ms. Johnson?
Yes, Your Honor.
How old is the child?
1 year old.
And boy or girl?
Boy.
Name?
Joel's Vaughn.
How do you spell that first name?
Juelz.
Juelz, all right. And Juelz lives with Ms. Johnson.
Yes, Your Honor.
And Ms. Johnson lives in College Park.
No, Your Honor.
Where does she live now?
I'm not sure.
Okay. When did you last communicate with Ms. Johnson?
If I'm not mistaken, I'm not.
Before you got locked up? Or have you guys spoken? I'm not asking to get you in trouble. I'm just curious when you last connected with Ms. Johnson. Has it been since you were locked up?
Yes, third
Okay.
party with my mother.
Okay. And does your mom say where Ms. Johnson is?
No, I believe she has an address though, but she never told me.
Okay, so it's not secret, you just don't know what it is. Any reason to think she lives in Rex?
No, sir.
Okay, but that's where you will go to is Rex.
Yes, Your Honor.
And this forklift job that you'll get, would that be more in Rex or more near College Park or?
In Henry County, Rex.
Okay. All right. Anything you want to add?
No, Your Honor.
How long have you and Ms. Johnson known each other?
For going on 3 years, I believe.
When you get out, I know you're going to need to connect with Ms. Johnson because of Jules. You have a kid together. Do you plan on talking with Ms. Johnson about other stuff? I don't know if yes, there'll still be a relationship between the two of you, or simply.
Haven't exactly spoke on that, but as far as me legitimizing my son, yes, Your Honor.
You plan on doing that?
Yes.
Okay. All right. Well, if you don't have any other questions, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. You don't feel like anyone's forcing you to do this?
Oh, Your Honor.
And you understood everything we've been talking about?
Sure, Honor.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that for small probation violations, that's an issue for you and probation. But if it's big, you get arrested again, that's an issue for me. Ms. Wood, can my staff sign the indictment on your behalf?
Yes, please.
Mr. Vaughn, can we sign for you?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
Okay. Mr. Vaughn, I am going to sentence you on count 4 to 4 months to serve. Count 5 is 4 months to serve. Those will run concurrently with each other. Count 2 will be 5 years. It'll be probated. That'll run consecutive to count 4. And count 3 will be 5 years to serve, probated. That'll be concurrent with count 2. Structured in a kind of funny way, but the net effect is you're going to need to serve 4 months. You'll get credit for all the time you've been in. You've been in for almost 4 months. And then you'll be on probation for 5 years. Special condition of probation number 1 is no violent contact with Ms. Vaughn. With Ms. Johnson. You can see her, you can be around her, but if it's hands-on in a way that she doesn't want and calls the police and there's evidence of it, not only is that another crime, and you don't get any more misdemeanor family violence batteries. It'll be a felony next time, but I could revoke all of your probation, and I'll revoke a bunch of it if I conclude there's evidence that you hit her, you choked her, you slapped her, you threw something at her, did anything she didn't want you to do. Special condition number 2, complete the family violence intervention program. And special condition number 3, 60 hours of community service. I will set a behavioral incentive date of August 10th of 20. Ms. Tucson, is it 2 years or 3 years for a behavioral incentive date?
It starts at 2 years.
Okay. I will set, I'm going to change that out. I'm going to set a behavioral incentive date of, what is this? This is August, that's 8 and 6 is 14, February. February 10th of 2026. So that's 2.5 years. So February 10th, 2026, if you've knocked out family violence intervention program, all your community service, you should be done with both those, no problem. And probation has gone fine, no arrests. Ms. Johnson is not calling the police or anything. Then we can shut down your probation early. So that's about half of the probation.
Thank you.
Well, you can thank me if you do well while you're on probation. If you don't do well, that date doesn't mean anything. You blow right through it and you stay on probation. I think I covered everything. Ms. Wood, anything else?
No, Your Honor.
Ms. Willingham?
Nothing from the state.
Okay. Ms. Tucson, Mr. Vaughn's going to live in Rex, Georgia. What kind of reporting instructions do you want to give him? He's going to get out in the next few days.
Yes, I was actually looking that up when you guys were speaking. Miss Wood so kindly gave me his address and phone number. Mr. Vaughn, 470-433-7281. Is that where I can call you, or is that a relative?
A relative,
And whose number is that?
my mother.
Okay, so that's the number that I'll have in file. I can call her to send her reporting instructions.
Yes, ma'am, you can.
Okay, and Judge, you stated he will be released soon?
Yes, he's serving 4 months, but he's done about 99% of those 4 months.
Okay, so we'll have report date for him on August 24th as well at 10 a.m., but this will be in Clayton County. Clayton County's address will be 1331 Citizens Parkway in Morrow, Georgia. And I'll get this information over to your mom, Mr. Vaughn. What's her name?
Tiffany Smith.
Tiffany Smith. Okay, I will call her to give the information to her, but just remember August 24th, 10 a.m. at the Clayton County Probation Office.
Let me do one more thing, Ms. Tucson. I'm going to waive Mr. Vaughn's probation supervision fees for the first 3 months of his probation while he gets back to work and deals with financial issues.
Thank you, Judge.
You're welcome.
There's the date, the time, the address, and the phone number. Don't be late, okay? And if you're, for whatever reason, you should be released by then, but if not, call our office and let us know, okay? Thank you. Email her. You're good to go. Good
Thank you,
luck.
Jan.
Good luck. All right, we've got Lowe. Is that it, or is there one more?
And Bagwell, Judge.
And Bagwell. Why don't we do Bagwell?
He's still, and that's a misdemeanor, please, so it should be short.
Okay.
Bagwell?
He's not here. He's virtual.
Oh.
Mr. Bagwell, been very patient. If you want to pop on, I gotta find that calendar.
Yes, sir. I'm here.
All right, let's get you on the screen. There he is. Give me 1 second to find you.
No problem.
This morning's calendar. Number 5. All right. Ms. Willingham, are you ready?
Yes, Your Honor.
Okay, this is position 5 from this morning's plea and arraignment calendar. State versus Joseph Bagwell, 23 SC 187977. By now, Mr. Bagwell, you have watched a number of pleas. This is going to be a similar process. So please answer all the questions you get truthfully and completely. And also let me know if you've got any questions of your own. Yours is going to be a little different from most of them because you are now virtual. You're not here in court. So I need you to share with me that you're willing to waive 2 rights that you have. One right is your right to be here in court. You look like you are in a car instead. Are you waiving your right to be here in open court for your plea?
Yes, sir.
Your other right is to have Ms. Wood right next to you in case you've got a question. You can lean over and whisper it in her ear. She's here in court. You are in that car. If you need to speak to her privately, that's easy to do. She'll step right outside. She can call you up and we'll do that. But for the time that we are on the record and speaking as a group, you and Ms. Wood will not be in the same place. Do you waive your right to have your attorney with you?
Yes, sir.
Okay, let's get going. All right.
Okay. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down.
Okay.
Please state your name and your age.
Joseph Bagwell, 43 years old.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
I graduated technical school.
Okay. Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
I do understand. Yes.
The negotiation in this case is that counts 1 and 2 will be null price, and you will be entering a plea to count 3, battery family violence, with 12 months probation. You are to have, I'm sorry, I need to go back to the special conditions. No contact with the victim, complete family violence intervention program, no weapons, drugs, or alcohol. Is this what was explained to you?
Yes, ma'am.
You're pleading guilty today to battery family violence with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, I'm not.
You heard me tell the court that the negotiation in this case is 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which in this case would be 12 months in custody?
Mr. Bagwell?
You muted, you got
I'm
muted.
sorry. No,
Mr.
I
Bagwell.
didn't. I didn't mute you. The phone rang and I couldn't stop it. I had to stop it. So
Okay. I'll repeat that question. I said, you heard me tell the court that the negotiation in this case is 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which in this case would be 12 months in custody?
Oh, yes, ma'am. I understand.
Okay. Should the court sentence include a period of probation, you will be required to obey both the general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no contact with the victim, complete family violence intervention program, have no weapons, drugs, or alcohol during the course of your probation. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, I am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
I do not.
Have you understood everything I've asked you so far?
Yes, I have.
Understanding all of your rights, do you wish to enter a plea to these charges today?
I do.
Is your decision to plead guilty made freely and voluntarily?
Yes, it is.
Did you in fact commit the offense to which you are pleading guilty?
Yes,
Are you a United States citizen?
I am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
I do.
Your Honor, if the state were to proceed to trial with this case, we would prove beyond a reasonable doubt that on March 19th, 2021, Corporal Hardy was dispatched to 4810 Ben Hill Road, South Fulton, Georgia, in Fulton County, in reference to a fight call. Upon arrival, he spoke with Amy Burnett, who told the officer that her boyfriend, the defendant Joseph Bagwell, had assaulted her twice. Ms. Burnett said that around midnight, Mr. Bagwell began asking her to travel to a location she didn't recognize. When she refused, Mr. Bagwell grabbed her by the throat and began to strangle her. Ms. Burnett called the police, but refused to give any information on the incident when the officer showed up. 2 hours later, police received a second call to the residence from Ms. Burnett's stepfather, Austin Daniel. Ms. Burnett told Corporal Hardy about the two separate incidents with Mr. Bagwell that both ended with her being strangled, and Corporal Hardy noticed bruising on Ms. Burnett's neck, as well as bleeding from her nose and ear. EMS was dispatched, but Ms. Burnett refused treatment. While awaiting for EMS, Mr. Bagwell returned to the residence where he was detained by Corporal Hardy before being arrested. Your Honor, the state has had an opportunity to speak with Ms. Burnett in this case, and she does not actually wish to proceed forward with the case at all. I explained to her at that time that the state would not be dismissing the case, but I would try and resolve it short of trial. I have tried to call her back to notify her of what the state's final plea offer was. She has been hitting ignore my calls. So I don't think that she has any issue with the resolution that we've reached.
Okay. I hope some people take your calls. It sounds like you make lots of phone calls that people ignore, and I feel bad for you, Ms. Willingham. I think it goes with the territory. It's not you. I think it's the role. Thank you for, yep. Thank you for sharing that. Ms. Jackson, criminal history for Mr. Bagwell, if any.
Yes, Your Honor. The defendant has 30 cycles. The defendant's last arrest was June the 16th, 2021 in Fulton County for a probation violation. The defendant does appear to have prior felony convictions, one in 2017 for possession of controlled substance. It's one in 2014 for 2 counts of robbery. It's an additional one in 2014 out of Cowardly County, Georgia, for possession of Schedule I controlled substance. It's one in 2013 out of DeKalb County for possession of methamphetamine. It's one in 2008 for aggravated assault. It's one in 2007 out of Henry County for theft by taking. And he received first offender treatment in 2007 out of Henry County for financial transaction card fraud. There was no seal date available. The defendant does have misdemeanor convictions. It's one in 2018 out of Peachtree City for driving while license suspended or revoked and fleeing or attempting to elude an officer. One in 2016 out of Dunwoody, Georgia, for driving while license suspended or revoked. And he does appear to have a history of failure to appear, says one in 2019 and 2 in 2018, Your Honor. Nothing in addition.
Mr. Bagwell, you have a license on you now?
I do, sir.
Can I see it?
Sure. It's valid, but I'll show it to you. Here you go.
Oh, you have more hair now.
Yes, sir.
All right.
I do a few things different.
Okay. Ms. Burnett at the time was someone with whom you were romantically involved? If we rewind, this was a while ago. I get that. This was almost 2.5 years.
Yes, sir. Yes, sir, it was.
Okay.
She was my girlfriend at the time.
Got it. But that's not who was in court with you today.
No, sir, that was a different girl.
Okay. Do you remember that girl's name?
Yeah, it's Crystal Tanner. She's my future wife. So
okay.
I won't be with any other woman.
Ms. Wood.
Thank you, Judge. As you know, I've spent a little bit of time with Mr. Bagwell. He is Ms. Feely's client, but from my brief conversations with him, it was apparent that he was eager to put this behind him. It is a 2021 incident and he has moved on himself. He is an electrician by trade.
He served 127 days from March 19th, 2021 to July 23rd, 2021. So he wanted to make sure that those dates were on the record, and he just asked that you accept the state's recommendation in this case.
Got it. Okay. So, Mr. Bagwell, I'm a little torn here. I'm not going to upset the apple cart, but given your criminal history and some of what I've heard, this seems light. But I'm also recognizing that it's 2.5 years since then, and Ms. Burnett has decided to move on. And the main thing that I'd be concerned about is that you stay the heck away from her. And it sounds like you're prepared to do that. So maybe you have turned a new page in the book of life. I hope so. And this is more consistent with your past than your present. Because your past was pretty busy in the court system. I do find there's a factual basis for your plea and that your plea is knowing and voluntary. Do you feel like anyone has rushed you into this, or this was your own decision to move forward with the misdemeanor plea?
This was my decision, sir. No one rushed me.
Okay. And no questions about anything we've talked about?
No, sir. Everything's clearly understood.
Okay. Ms. Willingham, can we sign the indictment on your behalf?
Yes, Your Honor.
And Ms. Wood?
Yes, Judge.
And Mr. Bagwell, is it all right if we sign the indictment for you indicating your misdemeanor plea?
Yes, sir.
All right. I'm going to sentence you to 3 months to serve, followed by 9 months on probation. So it's a total of 12 months. You'll get credit for all the time you've already served, so you're not going back into custody, but I want your sentence to reflect a custodial segment. You'll be on probation for 9 months. Special condition number 1, it's the most important one, and it's the one if you violate will cause me to revoke all of your probation, and that is no contact with Ms. Burnett, not direct contact. You don't call her, you don't write her, you don't post something online, but also if you happen to have any shared friends, you don't use them to get to Ms. Burnett, even if it's to say, hey, I hope you have a good holiday. If she has proof, it needs to be proof, not just her say so, that you were trying to contact her or use someone else to contact her, that'll violate your probation. And special condition number 2 is that you complete this family violence intervention program, which is a series of classes designed to have something like this not happen again. You will get reporting instructions for misdemeanor probation from Ms. Wood or Ms. Feely. That's nothing I can give you now, and it's not felony probation, but you'll get information about who to call or where to go, and you'll need to report on that day or call on that date, or they're going to send me a warrant to sign, which I will do. Ms. Wood, anything? Yes, sir, Mr. Bagwell.
Oh, I said understood.
Okay, great. Ms. Wood, anything else on behalf of Mr. Bagwell?
No, Your Honor, thank you.
Mr. Bagwell, any questions about what we just worked through?
No, sir.
Ms. Willingham, anything else in connection with Mr. Bagwell's case?
No, Your Honor.
Okay, thank you, everyone. Mr. Bagwell, you're free to go. Just be on the lookout for that communication from your lawyer about how to connect with misdemeanor probation.
Yes, sir. Thank you.
All right. So I think all that's left is Mr. Lowe.
Yes.
Okay, let's do it. One more. Ms. Jackson, can you hang with us?
I'm trying to hang with you, Judge.
Excellent. Thank you. Hey, Mr. Lowe, come on up to the podium here.
Sir.
Just what we talked about, but this is. Okay, right there. We're ready, Judge.
Excellent. Mr. Lowe, you are position 5 on our final plea calendar, 23 SC 186307. You're charged with burglary and a couple other things. Ms. Willingham, who you can see on the screen there, is the prosecutor on your case, and she is about to put you under oath for your plea conversation. Have you pled guilty before to a case?
No, sir.
All right, so this is a new process for you. Ms. Willingham's going to ask you a bunch of questions about your rights as a criminal defendant, et cetera. You need to answer those truthfully and completely. But if she says anything, or if I say something that doesn't make sense, confuses you, whatever it is, please let me or Ms. Wood know so we can explain it. Will you do that?
Yes, sir.
Okay. Ms. Willingham.
Yes, Your Honor. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your name and your age.
Darius Lowe, 32.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
12th grade.
I'm sorry?
12th grade.
Thank you. Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case, as to count 1, is 5 years to serve 6 months. As to count 2 is 5 years to serve 6 months to run concurrent with count 1. And as to count 3, cruelty to children in the 3rd degree, serve 6 months to run concurrent with all other counts.
Yes, ma'am.
And you would have to complete a family violence intervention program, have no contact with the victim, complete 100 hours of community service, and have no weapons. Is this what was explained to you?
Yes, ma'am.
You're pleading guilty today to burglary in the 1st degree, aggravated assault, and cruelty to children in the 3rd degree. And I'm sorry. Burglary in the 1st has a minimum of 1 year and a maximum of 20 years. Aggravated assault has a minimum of 3 years and a maximum of 20. And cruelty to children in the 3rd degree has a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything anywhere?
No, ma'am.
You heard me tell the court that the negotiation in this case is five years to serve 6 months. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to complete the family violence intervention program, have no contact with the victim, complete 100 hours of community service, and have no weapons. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of 2 ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years for the felony offenses and 12 months from the date the sentence is entered for the misdemeanor offense. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you're found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Sorry, Your Honor, I'm switching over to the police report. If this case were to proceed to trial, the state will prove beyond a reasonable doubt that on December 7th, 2022, at approximately 20:41 hours, Officer B. Jones, along with Officer S. Henry, were dispatched to 1197 Joseph E. Boone Boulevard in reference to a dispute call. Upon arrival, Officer Jones met with the reporting party, Miss Alicia Andrews, who stated she has been in an ongoing dispute with her estranged boyfriend, a male by the name of Kendarius Lowe. Ms. Andrews stated this evening around 19:30 hours, Mr. Lowe arrived at her apartment. Ms. Andrews stated she heard Mr. Lowe pushing his way through the front door. Ms. Andrews stated the suspect pushed past a dresser she had blocking the door. She stated that after making his way inside the apartment, the suspect made a statement to the extent of, "Why are you telling my business to the neighbors? And why aren't you answering my calls?" The victim stated she then ran to the bedroom, grabbed her cell phone, and ran to the bathroom to call the police. The victim stated after the 911 dispatcher answered the phone, the suspect became angry and punched the door, forcing his way in. It was stated by the victim that she was then drugged from the bathroom to the bedroom where the victim's 4-year-old son was located. The victim stated the suspect then choked her with his hands, and the victim stated she could not breathe. She stated that she was not released until the victim's son made a statement of, "Let my mommy go, she will call the police." The victim stated the suspect then left the scene. She stated that the suspect and her were living together from July 15th of that year until August. She stated that she has applied for temporary protection. At that time, she had applied for a temporary protection order and had spoken to a judge. And nothing further as to the facts, Your Honor. If you could just give me a moment to switch back over to my notes about my victim contact.
Okay.
Your Honor, I last spoke with Ms. Andrews on the 2nd, and I notified her at that time of what the state's offer was. She asked that it be no violent contact, and I actually think that I asked for no contact, but she asked specifically for no violent contact because they have a 5-month-old child. She stated that the defendant has a substance abuse problem, and she would like to see no drugs or alcohol and random screening, which were not things that I initially provided in my offer. So I didn't want to add those on. I don't have a problem changing to the no violent contact, but I recognize that adding in no drugs or alcohol is something that random screenings as to drugs and alcohol is not something that was previously discussed. But I did want to at least bring it to the court's attention that the victim believed that drugs and alcohol played a factor.
Okay. Thank you.
Thank you.
Anything else?
Nothing from the state.
All right, Ms. Jackson.
Yes, Your Honor. The defendant has 27 cycles. The defendant's last arrest was May the 11th, 2020 in DeKalb County for robbery by force. There was no disposition for that arrest. The defendant did receive first offender treatment in 2010 for possession of tools for commission of a crime. That case was sealed July the 6th, 2017. The defendant does have misdemeanor convictions. One in 2019 out of Rockdale County for simple battery and criminal trespassing and giving false information to an officer. There was one in 2016 out of DeKalb County for 2 counts of simple battery. There was one in 2013 out of DeKalb County for possession of marijuana less than an ounce. And there was one in 2012 out of DeKalb County for giving false information to an officer. Just an additional one in 2012 out of DeKalb County for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you, Ms. Jackson, and thank you for a long day. You are free to go. Appreciate your help.
Thank you, Judge.
Ms. Wood.
Thank you, Judge. I just want to let the court know, we checked with our colleagues in the DeKalb Public Defender's Office that robbery is in their version of CP land. So I don't think there's a hold, but I did just want to let the court know that information.
Okay.
Mr. Lowe is 32 years old. He is a high school graduate. He has 4 children, and he's been in custody since January 24th of this year. So I believe he's done the 6 months. He is hopeful that he can return to work at a temp agency. He is a licensed forklift operator. So we would just ask that you accept the state's recommendation. And he did want me to ask if the court would consider waiving the probation fees for the first few months, just until he gets back on his feet and can pay for the family violence intervention program.
Okay. Mr. Lowe, you have 4 kids total?
Yes, sir.
One of the kids is with Ms. Andrews.
Yes, 5 months.
5 months old, boy or girl?
A boy.
Name?
His name is, Kareem. I'm tripping. I had to think of all my kids. Kareem.
Kareem. Okay, so Kareem, does Kareem live with Ms. Andrews?
Yes, sir.
Your other 3 kids with one other woman or multiple women?
It's with 2 other women.
Okay, and do they all live with their moms?
Yes.
Okay, so none live with you?
No.
When you get out, where are you gonna stay?
Go back to my family house until I can get on my feet and find me my own.
Okay, and is your family's house on Joseph E. Boone, or that's where Ms. Andrews lives?
That's where she stayed.
Okay, where does your family stay?
2437 Medium Lane. It's in Decatur.
Okay, so you go back to Decatur.
Yes, sir.
All right. Your preference is not that it controls here, but that you be able to have contact with Ms. Andrews because of Kareem, or because you and Ms. Andrews might still have something going on?
Kareem, I haven't seen him since I've been in here.
Okay. I guess that makes sense. If he's 5 months and you've been in for 6 months, he was born after you got locked up.
February the 20th.
Okay. Is he doing okay?
I don't know.
You don't talk with Ms. Andrews?
No, sir.
Okay. All right. How'd you know his name is Kareem?
My mother.
Okay. She has seen him?
Yes.
Does she say he's doing okay?
She said he's fine.
All right. Do you have questions about anything?
No, sir.
All right. Well, Mr. Lowe, I find there's a factual basis for your plea. In December of last year, you were trying to get into a place you shouldn't have been getting into, and it sounds like you didn't handle it real well. I'm sure there's a little more to the story. I'm not taking sides here. There often is just that when it's I'm going to call it a domestic situation, but that doesn't justify what you did. I don't have Ms. Andrews in front of me, but my guess is you're bigger and stronger and you need to handle it differently. Especially if it's not your spot and you want to get in there. It's not your spot. So you need to only get in if she's going to let you in. Even if your stuff is in there, there's a way to get your stuff out of someone else's place, short of barging on in. And it sounds like she's got another kid and you probably scared the daylights out of that kid with whatever was going on. And she may have scared the kid too. This kid should never watch parents or loved ones getting physical in a negative way in front of them.
Yes, sir.
End of sermon. All right. I find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. Is that correct?
Yes, sir.
And the knowing plea is simply one where you've understood everything we talked about. It sounds like you understand.
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you're on probation, which you will be for 5 years, that if you have a minor violation, you and probation work through that. But if it's a significant one, meaning you get arrested or it's a violation of any of the conditions that I impose, those will be called special conditions. That comes back to me. Ms. Wood, can my team sign the indictment on your behalf?
Yes, please.
And Mr. Lowe, can we sign it for you?
Yes, sir.
And Ms. Willingham?
Yes, Your Honor.
Okay. Mr. Lowe, I'm going to sentence you on count 1 to 5 years to serve. 5 years to serve 6 months with the balance probated. Count 2 will be 5 years to serve 6 months, balance probated. And count 3 is just 6 months to serve. They'll all run concurrently with each other. So you're actually on probation for 4.5 years, not 5 years. You'll get credit for the time you've been in. You've done more than 180 days, so you ought to get out in the next day or 2. You'll be on probation for 4.5 years. Special condition number 1, complete a family violence intervention program. That's not one class or one day, but it's a series of classes over time. Number 2, no violent contact with Ms. Andrews. So you can still interact with her because you need to help take care of Kareem, but no hands-on in a way that she doesn't want.
Yes, sir.
100 hours of community service. You don't have to do those right away, but you do need to take care of them sooner rather than later. You're going to need to submit to a drug and alcohol abuse evaluation. So someone who knows a whole lot more about what an addict does with alcohol or drugs is going to spend some time with you. And if that person recommends treatment, that treatment is part of your probation. No firearms while you're on probation. And 100 hours, I think I already said 100 hours community service. So those are all of the conditions. And I think that's it. Ms. Wood, anything else on behalf of Mr. Lowe?
No, Your Honor.
Ms. Willingham?
No, Your Honor.
Okay, last thing, Ms. Tucson needs to talk to you about reporting to probation. You're going to be living in DeKalb. And so for now, your probation will be supervised in DeKalb. If you, as you said, get on your feet and find your own spot and it's in Fulton, we move your probation over to Fulton. But for now, it's going to be in DeKalb. Ms. Tucson?
Hi, the DeKalb office is located in Conyers, Mr. Lowe. Do you know where it is?
Yes, ma'am.
Okay, so it looks like when will you be released from custody?
Next day or 2?
Okay, so Miss Wood kindly gave me his information as well. Just to confirm, it's 404-447-5782.
Yes, ma'am.
And whose phone number is that?
My father,
What's his name?
Christopher Lowe.
Okay, so I'm gonna have you report to probation on the 24th of August at 8 a.m. And their address is 981 East Freeway Drive in Conyers, Georgia, 30094. And I will call your father to confirm that, okay?
Okay, thank you so much.
All right, no problem.
All right.
Keep that with you, okay?
All right, I think that is it, my friends. Long day, productive day. Thank you, everyone. Tomorrow, drug court in the morning. Doesn't involve any of you except old 12 hours Gordon here. But I think we have a final plea in the afternoon. You're covering drug court? Oh,
Yes, Judge.
that's a new one. Okay. And then we've got final plea in the afternoon. So
And
thank you,
Judge, I
everyone.
did get my warrant. I got it. Well, I don't have it in my hand, but Mr. Abate said he put it on my desk. So thank
Excellent. Yeah, I gave it to him. So you've got it. You'll be able to be up close and personal with it tomorrow, assuming you can get in the building.
you. Thank you, Judge.
All right. Thanks, everyone. Thanks, Ms. Rivers.
Good night, Judge. Have a good night.
All right. We'll hear you tomorrow for drug court.
Yes, and I'll be there on Thursday.
Okay. Sounds good.